ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದು ಕೋರ್ಟ್ ಹಾಲ್ ನಂಬರ್ 3 ಅಲ್ಲ? ಹಲೋ ಹಲೋ ಸರ್, ಕೋರ್ಟ್ ಹಾಲ್ 3 ಅಲ್ಲ?
ಪೋರ್ಟಲ್ 2 ಅಂತ ಬರ್ದಿದ್ದಾರೆ, ಬಟ್ ಲಿಂಕ್ ಇರೋದು 3 ಇದೆ.
ಅದೇ ಅದೇ ಕನ್ಫರ್ಮ್ ಮಾಡ್ಲಿಕ್ಕೆ 2 ಅಂತ ಬರ್ತಾ ಇದೆ.
ವಾಟ್ ಅಪ್ ಸರ್?
In which lordships are issued emergent notice, the address has changed and therefore the service is not getting completed. To show the changed address, can it be listed tomorrow, day after it?
Oh, we don't have roster anymore.
The arbitration matters.
Still don't have. Our appeals are arbitration, apart from commercial appeals and arbitration. That is the
Lordship,
roster.
Lordship. My apologies.
We mentioning list 1, page 1, see number 1 to 3, page 2, number 4 to 13.
My lord, the serial number 11, my lord. On record counsel is taking treatment. That's not a
PMLA matter.
PMLA.
You inform the other side?
2 weeks time maybe.
Yes.
Page 3. Page 3, number 14 to 17. Page 4, 18 to 20. Page 5, 21, 22. Page 6, 23 to 25. Page 8, 26 to 28. Page 9, 29 to 31. Page 10, 32 to 33.
Lordships.
Page 11, 34 and 35.
Serial number 38, Your Lordship.
34.
38, Your Lordship. I appear for respondent number 1. I have informed the petitioner.
I am for appellate, madam. She has informed me.
38. Yes.
Yeah, please.
With my
I
lord's
will have it after 2 weeks, Your Lordship.
Please, please, please.
My
My
lords,
serial number 35. My lords, it is listed under the head final hearing, but process has to go, my
Right.
lords. A week's time.
With my lords kindly, my lord, serial number 33, my lords. I appear for the appellants in this matter, my lord. My lord. I pray for short date, my lord, next week, any date, my lord.
Have you informed the other side? Who appears?
Not
There's
here.
no appearance.
23.
23.
Government advocate appears.
33 minutes.
23.
Government advocate. 33 now.
23. Is it
33.
23 or 30? 23 or 33, please?
33, please, my lords.
There are the lawyers. Yes, final hearing matter. Can it be on some other day? Please inform the other side. There is appearance for R1. ASG for R2, CGC for ASG for R2 and 3. Please inform.
Please.
serial number 34, my lord. I am appearing for the appellate. My lord, I informed the other side, my lord, in the morning itself. Could it be, my lord, after some 2 weeks, my lord? Oblige.
Page 13, 37 to 43.
Serial number 40, my lord. I informed the other side, my lord. Not accommodation of 2 weeks for the appellate.
Page 14, 44 to 48.
My lord, I'm
Serial number
appearing-
46, my lord. Serial number 46, my lord. I appear for the respondent.
I am for the appellant. That I,
You're opposing the, yes,
My lord,
please submit when it is taken up.
my lord, I'm traveling, my lord, today. I have some personal inconvenience today. Any day, my lord. Any day this week is fine.
Tomorrow, day
Day after tomorrow.
Tomorrow.
Great.
Listed tomorrow.
Tomorrow.
My lord,
Great.
serial number 47, my lord. 47.
Yes,
Senior counsel A. Shankar sir has been engaged in this matter. Due to some personal inconvenience, he is not able to appear today. Humbly request to adjourn this matter after 2 weeks, my lord.
it's a final hearing matter. Have you informed the other side?
Yes, my lord.
Please make submissions after informing the other side as well. We
have
don't know
informed-
whether they have any urgency in the matter.
My lord, I appear for the respondent
Can be.
state. Please.
Yes, 47.
Much obliged, my lord.
The council is unwell, my lord. Firstly,
Serial number 3.
admission, my lord.
For the respondent in the matter.
Madam.
Yes.
Number 3.
Nalega.
Number 3,
Ah.
the respondent.
The council
Divorce
is.
granted, restitution dismissed.
Please, my lord.
Can be on some other date. There's gold also involved. Yes. Thanks.
My lord, serial number 25, my lord, for the respondent. 2 weeks of time for filing of the serial number 25, my lords. We'll file the synopsis in another 2 weeks, my lords. If a short accommodation can be,
Have you informed the other side?
no, my lords, we will inform
Please
them.
inform and
Please,
make the
my lords,
submission.
please.
Yes.
It is for the 25.
Somebody else is also there. Yes.
List 1, admission, seal number 1, submit, yes.
Appearing for the appellant.
Yes.
Amendment has to be carried out.
Respond number 1.
I appear for respond number 4A and B, my lords, in this matter.
Amendment has to be carried out, my lords, and I'll serve the copy also. Copy also to the respondent. We had also engaged the senior counsel, my lords. There is some personal inconvenience.
The lordships may kindly have this matter on 23rd, my lords.
Do the needful in the meanwhile.
Yes, my lords. 23rd.
23rd, my lord.
Counsel for the appellant submits that a senior counsel has been engaged in seeks time. List on
23rd, my lords.
Deeply obliged.
Like-
Seal number 2, Srinivas V.
Yes.
Challenge the order of dismissal of the petition filed seeking dissolution of the marriage.
Cruelty and desertion
Yes, my lord.
dismissed.
Yes, my lord. The desertion and the ground of cruelty as well. Now, my lord, the respondent, though she has appeared and filed a statement of objections, she has never stepped into the witness box, my lord. My lord, the trial court have dismissed it solely on the ground that she may join the petitioner in the later course. Your lordship can kindly come to paragraph number, my lord, 14, my lord. 14, page number 17, my lord, in the judgment. The respondent has clearly stated in her objection that the respondent is having hope that if the petitioner may realize his mistake and join with her to lead marital life. Further contended that the respondent being a respectable lady having to maintain the same and she has no intention to leave her husband or no intention to withdraw the marital relationship with him. My lord, to prove that she has got such an intention, she has never taken any steps. She has neither stepped into the witness box.
Not the question at all. Question is whether you have proved cruelty and desertion.
Yes, my lord. Desertion, my lord, she is
Yes.
accepted. We are living separately from the year 2015.
Desertion, that does not mean that desertion is established. It only means that you're living
Let
separately.
trial court records be called.
Yes. Notice to the respondent.
Notice agide. Notice is done. my lord.
Notice is
I have
already-
Notice is done. I have deposited the litigation expenses of 10,000 before this court.
Yes, admit, call for the trial court records. Yes. After maybe 3 or 4 weeks.
3 urgent, 4, Ramesh RS. Seal number 4, Ramesh RS.
Here also it was representation in the earlier date also. Is this the case? There was no representation earlier date also. Divorce dismissed, restitution allowed. Husband's appeal, no representation. Issue notice. Anyway, it is a first appeal.
5, Fire Shop. Number 5, Fire Shop.
Divorce granted. Restitution dismissed. Here also we can order notice. Husbands.
6, Basarajappa DR.
What is happening? Divorce granted, wife's appeal. There's also an IA for stay. List it on some other day. It's a stay petition. Mm.
7, PB Sidramaya.
My lord,
Sit
so
next week. They mean,
one is a land acquisition case, my lord, for enhancement.
just a moment, just a moment. This is item 7,
Item 7 is a land acquisition case, my lord.
compensation.
Compensation. Claimants
Enhancement
appeal,
allowed in part.
yes. My lord, in adjacent land,
Appeal for further enhancement.
further enhancement.
Notice.
My lord, for the first respondent, government advocate may be directed to take notice. For R2 Shanti Bhushan,
Yes.
I will serve the, right now I will serve the copy.
It's notice. Please serve the copy today.
Yes, definitely. For government, right now I will serve my lord.
No. Because there is an IA and it's a wife's appeal.
For R1, I have served the copy, my lord.
Yes,
For R2 Shanti Bhushan, I will serve and report.
please record.
Yes.
Copy served on R1. Your
8.
counsel submits that copy shall be served on the SGI list. Yes.
I'm for the appellant wife, my lord.
Hmm.
The wife had
Wife's
filed for
appeal.
divorce and application.
Cruelty.
is-
Here again, judgment in Kannada. Judgment is in Kannada. Am I right?
I'll translate, get it translated. my lord.
Please. No, this is, no,
No,
this is
yes,
not
it
the.
is in Kannada.
Serial number 7,
8, my lord.
8.
Called 8.
8
Divorce
is-
petition is rejected, my lord.
Yes, 8 is in Kannada.
Yes.
Yes, please give a translated version,
Next Monday, my lord.
Monday.
Bless.
9. Vishwanath Kanavi.
I appeal for the appellant, your lordship. Appellant has been, your lordships.
Appellant husband, restitution allowed.
Restitution is allowed, your lordship. Divorce has been rejected, your lordship.
Hmm. Notice.
10. Mohammed Tahir.
Land grabbing,
Please.
section
There is
4(3).
there is a garadi mane or in the modern terms, a gym.
Correct.
Records stand in the name showing it as garadi mane for the last more than 40 years. There was an unregistered association which was managing it. In the year 2016, an association was registered and the name of association is shown along with the Gardi Mane. Now it is called as Jai Hanuman Vyayam Shala. The authorities, the only reason for giving the finding is they have sent a report saying name of Vyayam Shale or Jai Hanuman Vyayam Shale has been effected in the municipal records without a mutation.
Admittedly, it is not the case of the accused that the above said property has been granted by competent authority.
No, there is no question of anybody
Not
granting
the
because
case of the
it was-
accused that they have purchased the suit scheduled property either from government or from any competent person. Some of the records are standing in the name of Sri Jai Hanuman Garadi Mane.
and
That
that
is not a ground to come to the conclusion that management is the owner of the property.
Your Lordship may kindly see section 11.
Hmm.
The very concept of burden of proof
Hmm.
under section 11 has been misunderstood by court below. Your Lordship may kindly see where in any proceedings under this act,
T8 49. Has been changed.
section 11.
Just a minute. 4(3) says whoever contravenes the provisions of subsection 1 of subsection 2 shall on conviction be punished. No person shall commit or cause to be committed land grabbing by himself. Land grabbing in any form. What is land grabbing? Means every activity of grabbing of any land without any lawful entitlement and with a view to illegally taking possession of such land, or enter into or create illegal tenancies or lease and license agreements, construct unauthorized structures thereon, so and so, so and so.
Now kindly go to section 11. Where in any proceedings under this act, prima facie proved to be the land owned by the government, the special court shall presume that the person who is alleged to have grabbed the land is a land grabber. Now, my lord, even according to their case itself, for the last more than 40 years, land stands in the name of Garudi Mane. Before entering the name of this society, the property stands in the name of.
What was the mode of acquisition?
Neither I know it nor the government knows it. It's a property wherein
The order says that so and so conduct a survey. Thereafter, they prepared a report. And
yes, my
in
lord,
the report,
that
it
is
stated
after
that
this complaint. After this complaint, they prepare a survey.
Hmm.
Kindly see para 19 of the order, page 28. Admittedly, contents of exhibit P6 is proved by the prosecution by adducing evidence of PW2. No doubt, exhibit P2 and P3, it is not specifically mentioned that scheduled property is a government property. But on the other hand, the accused has not established on what basis entry has been made. 40 years back, an entry has been made. More than 60 years, actually, not even 40.
What was the extent?
It is 3 guntas of property where admittedly Garadimane is situated for the last 60 years. My possessory title itself is enough to rebut this land grabbing.
Is there another appeal pending?
As regards conviction, a separate appeal is filed that is stayed. And there is an application. What happened was the case was posted on 4/9/24 for consideration of admission and interim prayer. On 4/9/24, an interim order was granted. On 3 evening, according to respondents, of course, not only according to respondents, they have come and locked the premises without notice. Kindly see regulation 39.
When was this done?
That was on 3rd evening. Kindly see regulation 39.
Yes.
Regulation 39. The special court shall communicate its final decision or order in respect of the land to the affected parties and also to the Tahsildar or authorized officer to give effect to its decision. The Tahsildar or authorized officer, on receipt of the order of the court, issue or arrange to issue a direction in Form 5, deputing any officer not below the rank of revenue inspector to take possession of the grabbed land on behalf of the court and deliver possession of the land to the person ordered by the court. A copy of authorization issued by the Tahsildar or authorized officer shall be served or arranged to be served on the person in possession or occupation of the land as the case may be. Where the person in possession or occupation of the grabbed land delivers possession thereto voluntarily, officer so deputed under subsection 2 shall record the statement of the person to that effect and also record certificate in Form 6 and send same to the court. Where the person in possession or occupation of fails to deliver possession of that land voluntarily, the officer so deputed under so and so may enter the land, take possession on behalf of the Tahsildar. Therefore, a minimum requirement is a notice. Admittedly, no notice is issued. It appears Government advocate sent a communication saying matter had come up on such and such a date, it is posted to 4th. That communication, they thought the party might get some interim order. So 3rd evening, they come and put the lock. I have filed 2 applications, one for restoration, another for breaking open the lock.
May I make one submission? As per my information, my lord, the Tahsildar is supposed to submit a report as to the process under which he is taken possession. May I request my lords to take this matter up on Wednesday, my lord, I'll secure the records and the report.
Review of the matter. What was the date of the order?
Lord, this is on 24/9/2024.
No, it is, the order is dated 18/7/2024.
Please, ma'am.
If nothing has been done till then, what was the tearing hurry when the court was considering it on the 4th?
Yes, I'm aware.
Please get instructions.
I
from
just
CIA.
pray for 2 days time, my lord, I'll secure some instructions.
Yes.
At any date convenient, my lords.
Tahsildar as well as municipality both are served.
I'll check your instructions, maybe taken up day after tomorrow, my lord, I'll make my submissions.
Yes, learned
Grateful.
government advocate takes notice for the respondents and seeks for respondents 1 and 3
Please.
and seeks time to get instructions on the IA. IA number 3 and 4. List. Day after tomorrow, Monday?
Day after tomorrow is.
Monday. Day after tomorrow, where there are other combinations.
Please.
Grateful.
22nd. 21st, but the dates we have given don't affect us anymore. Right.
Preliminary hearing, till 11 adjourned, 12 Mallareddy.
Parliament elections 2019.
No, it is not
The
only
premises.
the completion of election process, please, my lord.
Hmm.
The non-est order, which is still operating against me, on account of which I am facing criminal, I means the office bearers of the institution, please, my lord, have been facing criminal prosecution, though the order is non-est. See, when I contend that it is non-est,
What happened to your section 482
that is still
application?
pending. That is still pending. And when I,
It out there.
your lordship, kindly, when I just submitted this before the other bench, please, my lord, the learned judge, single judge, has observed that anyway, the order which is impugned in the writ petition, the writ petition is disposed of without observing anything about the order, whether it is an honest order, whether it is a nullity, all those things. Therefore, it's still sustained. Therefore, you cannot urge that ground here. That's what it said.
If you're insistent, argue on the
Yes, please, my lord. It is only for the this limited purpose, please, my lord.
Passover or
My lord,
Having given my premises for
insofar as the chief electoral officer, the second respondent, my learned friend, Mr. Dodwad appears in that.
My lord, I am
on
appearing for respondent number 2 and 3, my lord, in this matter.
Yes.
Please.
We can hear this on the question of the legality of the order.
Please, my lord. My lord, any date, lordship may kindly fix a date, my lord.
Next week,
the
any
date may kindly be fixed, please, my lord.
Any date. It's only a
Only limited.
only on that limited.
That's
issue.
all, please, my lord. Whether
Because everything else is
that has been hanging on my head, please, my lord.
23rd.
I have to overcome from that criminal proceedings. That's all, please. Having given my premises for conducting of election, I have to face this humiliation, please.
You did not hand over voluntarily appears to be the contention. Yes, anyway.
So date.
23rd.
Okay.
Next. Number 13, Nitin A.
It was about the extended rounds in which I was not able to participate, but my learned friend.
Consider for a casual vacancy.
Yes, my lord.
Notification is dated 28/9/2024.
Yes, so now I am being informed that I think it is opened and necessary entries are made. Yes.
Yes, learned counsel on either side submit that the matter can be considered day after tomorrow. since the last round of counseling is, you call it counseling?
Counseling.
Last round of counseling is ongoing.
And it is
Day after tomorrow.
maybe noted that, my lord, that options have been made available for the candidate.
And that options have been made available for the candidate. List tomorrow,
Yes.
2:30.
Tomorrow, yes. Much.
Combinations. Those have been listed on Friday, whole day. The other combination, I mean, not Friday, Wednesday. Day after tomorrow. Correct, and then argue. Then if we are ready to do after, if we are ready to do.
Hearing on IAS, number 14.
Early hearing.
Chandranath
Early hearing.
Krishna.
What is this about?
Case is about a student who has got admission and later he did not join. He is seeking for refund of 27 lakhs. He paid. Matter was posted several times for hearing, did not reach. Therefore, I am before the court seeking.
If all of you are ready today, we can hear it.
Yes.
Pass over. The difficulty is that once we fix dates, it may not happen. Correct. What happened to that seat? Did you get another admission to the seat? You are for the institution. Did you get another admission for the seat? If that is so, you have to refund the amount. Your contention can only be this, that because the time has expired, you could not get. If as a matter of fact, you did have an admission for the seat, then there is no question, there is no need for any argument. It has to be refunded. You cannot be unjustly enriched. In respect of one seat, you cannot have 2 admissions and 2 fees. Therefore, the question is simply this: did you get an admission? If you have got an admission, refund it. Otherwise, we'll consider on the merits of the matter. That's the end of it. We don't require any long hearing on. If as a matter of fact, you did have an admission against the seat, that is the end of it. Can you tell us whether they got an admission?
State will not be aware of this admission, my lord, probably. I'll make my efforts.
Whether that seat stood filled up is the question. True, it may have been after the time prescribed, all that is true. But against one seat, there cannot be 2 fees.
And much before the cutoff date, a letter was given, my lord, and at their own instruction, and it is not returned for 7 long years.
You get instructions regarding that. A date
It's at 2:30?
tomorrow, my lord.
Tomorrow. Let's see. Tomorrow.
Please, grateful.
2:30, my lord.
Tomorrow. Please try to get instructions as well.
Please.
15, Rajgopal Naidu.
This is the wife challenging the divorce petition.
What is the temporary injunction you're seeking?
Preventing the respondent from contracting the second marriage.
Your Lordship, one short accommodation has been provided.
the other
For the
application.
purpose of contracting a second marriage. Indeed, no.
Yes, my lord, he has made attempts, and in fact, I have also filed application before the trial court.
Your lordship,
Was
we
pending.
have filed an objection regarding an IA. The objection has been. Yeah, copy has been served. If one short accommodation has been provided, we'll do the hearing in the next date.
Just a moment. What is the finding? It was granted on the ground of
But,
cruelty.
the
Indeed.
ground, my lord, that the respondent has admitted before the trial court that she is not interested to stay with the continue the marriage.
Hmm.
That is the only admission. And based on that admission, because the admission came because of the reason that the medical allegations have been made against her.
Hmm.
So making that, there was a ground also incorporated by them that she is suffering from mental illness.
Hmm.
It is because of the frustration she has answered during the course of cross-examination that the allegations have been leveled against me, false allegations, and that I don't want to continue the marriage. Only on that ground, the decree of divorce was granted. And nothing has been proved by producing the material evidence before the trial court that she was suffering from mental illness, though there was a ground, though there was a provision made out in the petition. 1B. 1B has not been proved by them.
No, just wrong. Only on 13.1(1)(a) and 13.1(3) is dismissed.
There was 1B
Hmm.
and nothing was made out.
No, that
and
is not
nothing-
granted on those grounds.
No material was produced based on 1B. But in spite of it, the trial court has allowed the petition, granted the decree of divorce against
Under
you.
1(a).
1A,
Yes,
1B.
that was also
1B,
there.
though they have taken up the contention,
Hmm.
the main allegations against the wife were the mental illness, schizophrenia. And nothing has been produced except the downloaded, the copies of, the online downloaded copies of prescriptions. What could be the prescription for the schizophrenia? And no prescription, no treatment, nothing has been produced.
Has not filed any appeal. Husband has not filed any appeal.
Yeah, nothing has been done. Nothing has been done. She has not been subjected even to medical.
This is not a ground for granting of the divorce. Why you are unnecessarily raising that point here?
No, initially,
On the ground of
the
divorce,
entire petition before the trial court is based on the mental illness of the respondent.
Is there a stay? Should he not be sitting?
Lord, I have the wife was getting interim maintenance earlier during the pendency. And I have also
Yes,
filed an
when do you
application.
want it?
Monday.
This next week. In the meanwhile, don't get married.
Much. 23rd, Mila.
Please.
25th. 25th. Please be ready on that.
16, Keshav M. Datta.
430 days.
430
Filing the
days.
appeal.
Take time to file my objections, my lords, to the.
You've not filed objections to the IA.
No, my lord, file my lords.
Non-filing of better affidavit.
I want to file. I have prepared it. If your lordships, please, I'll file it in the counter. I'll serve.
It's fine. Please file it and file your counter as well.
My lord, if
List
a
it after
date
2
be
weeks.
fixed, my lord, list after 2 weeks. If a date
weeks.
would be fixed, my lord. If a date,
Highly obliged.
grateful.
Maintenance is being paid.
Maintenance,
There's no maintenance order even in the trial court, my lords.
there is an application that I've preferred in this appeal. my lords. Grateful.
Highly obliged.
17,
Appearing for appellant. 17, I am appearing for appellant, my lord.
Yes,
That there is a delay
87
of
days.
87 days delay in filing the appeal.
Notice has to go.
Notice has to.
Notice. Notice on all the applications. Stay petition is ready.
18. Ramesha, MS.
Here also notice has to, notice. Only 5 days,
19.
but still notice has to.
Urmila
Yes.
Pula.
95 days.
95. Notice has already, she's been served, my lord.
Has been served.
Has been served.
Can we?
95 days in this, and for the appellant has been.
Heard both sides. I heard the learned counsel for the appellant. Notice on the respondent is served. In view of the amendments in the affidavit filed in support of the application for condonation of delay. The delay of 95 days in filing the appeal shall stand condoned. Admit. Issue notice to the respondent. Yes.
Trial court records may be called.
Call for the trial court records. This chapter service is complete.
Any date may be fixed, because she's already served.
Record system.
Yes.
Orders.
Listed.
Orders. Till number 20. Abhinay.
Connected matter,
That's
my lord,
38 guntas.
the connected matter service is to be completed. The state's appeal,
States appeal.
connected cross appeal.
Yes. Notices.
Will take steps, my lord.
Yes.
2 weeks time.
2 weeks time granted. In writ appeal 609 of 2020, 2 weeks time granted.
My case, my lord,
Complete
stays,
service of notice. In your case,
stays absolute. In
Yes.
case till next date of hearing, I think their interim order needs to be vacated, continued, my lord.
we see whether it is time bound in any case. If it is, extended till next date.
Great.
21. Nitin Prasad.
There was the direction to the government to file a report, my lord.
Encroachment.
Finally.
Comprehensive report of the zone. So getting to encroachment of the property.
Only copy. No.
Joint inspection. Explain number 21/1.
Yes, my lord.
5A30G extent. This does not corrupt as per the survey document. Boundary is demarcated as A, B, C, D, E, F, G, H. The above sketch.
My lord, in this case,
Just a moment, please. 17.25 guntas belonging to survey number 21/1 is encroached by site owners who said to got the allotments in government land situated on the southern side, adjacent survey number 1 of so as per local inquiry during inspection.
These are the two survey numbers in one.
1.50 guntas is utilized as road connectivity for these sites. As shown in the. This is the existing road.
There 1.5 guntas is utilized for the road. The lot blue lot what they have indicated in the blue, that is
Correct.
the encroachment, my lord, into the land. That certain persons, my lord, claiming to be, my lord, site owners, site allottees. But this encroachment is, lord, to be prevented. They can't, my lord, enter into my land and, my lord, construct. I am, my lord, the petitioner who succeeded before the alternate single judge. The problem, my lord, is moment, my lord, there is acquisition, my lords are aware. the RTC's, my lord, revenue records will be, my lord, changed, showing the name of the acquiring authority or the beneficiary.
Correct.
Now, for me to go to the court and say that there is encroachment, the difficulty is, my lord, none of the revenue records are in my name. Now, acquisition has been quashed, my lord, my learned friend has filed an appeal, my lord, challenging the order. But in the interregnum, my lord, both of us are helpless if there is any encroachment. My lord, his acquisition is quashed. My lord, I can't go to the civil court and prevent encroachment because, my lord,
It relies in his name.
yes, sir. So therefore, my lord, the state should do something in this interim period, my lord, and say that at least, my lord, if my lord, he succeeds, my lord, land will go to him. My lord, if he doesn't see the order is upheld, my lord, I will get back the land. But because of this, my lord, interim period, where the state.
Who are these persons? What do they, what is their claim?
They are encroachers, my lord. And they would say that they have got some allotment of sites by some local authority, my lord, which is still to be verified. Not in this survey number, but in the adjoining survey number. That is what the report also says.
Yes, encroachment zones, who said to got allotments in government land situated to southern side adjacent survey number. Survey number what?
Yes.
My lord, in this, the with lordship permission, my lord, if they any objection by learned friend, so let him put it on the records.
There is no objection.
No,
They're-
Yes, yeah,
They are okay with this sketch.
that's what I'm going to say. So that encouraging for who's going to be vacating, that also there. Let it come on the record so that we are able to be see that the encroaching by whom it is there and how to be clear that this
No, they are
situation.
also, how are they aware who the encroachers are?
My lord, now as per the report, there is some encroaches.
Correct. Therefore, find out who the encroachers are and tell them so that they can
Please.
make them parties.
Please,
How
madam.
else can we
We-
go about this?
We will get a clarifications with the concerned officer, my lord, we'll submit to the court.
Please
Let them
tell us.
prevent any further, my lord, what has happened has happened. But my lord, this should not be a gateway for others to, my lord, just
No,
walk
no,
into
we
the
have,
property.
that is not correct. And we have done, we have, I mean, encroachers, we have been stopped. That is the reason no further encroach. Only with regard.
My lord, that they will stop further encroachment.
Further encroachment shall not be permitted.
My lord, we will, this concerned, my lord,
Correct.
we will report it who's holding encouragement and that will be submitted.
And that further encroachment is also.
That we will
Please
take care. ma'am.
prevents that. Yes. There. Petition is allowed in respect of survey number 29, 30, 32, 33, 34, 35, 36. Where is 21?
21, my lord, is a part of the writ petition. It has been missed out, my lord, in the final order. By typing.
Sorry? 21 is not there.
21, my lord, it is a part of the schedule.
So therefore, the IA should not have been filed by you, it should have been filed by them.
Whatever it is, my lord. In all fairness, my lord.
Absolutely. You
Very well,
must,
my lord, that I
you
will
must file
undertake.
a review.
Yes, I will file, my lord, for correction, I will file that.
If as a matter of fact, this is
My
a
lord,
part,
writ petition is there, my lord, may I see in the paper book itself, in the writ petition, my lord, the schedule is very much there. The lords may kindly take.
page
Lord,
number,
Page number 45, my lord. Sorry, 44. And my lord, page 30. My lord, para A. 21 is there, my lord, which there is no dispute about that. I have produced the RTCs as well.
in respect of 21,
21 is there.
21 bar 1.
This number is left out while, my lord, the order was passed. I will take necessary.
That you'll have.
My lord,
to
either,
read it.
that's why I said, my lord, either way, my lord, either it will go to his benefit or any to my benefit.
But then,
Yes.
then if it is not there, the IA should be at his instance, not yours.
Yes.
The learned counsel for the respondent submits that the writ petition had been filed in respect of
Lord, various survey numbers.
for in respect of 21 guntas in survey number 21 bar 1 of Pillaganahalli village as well. And that the sir, that the mention with regard to survey number 21/1 has been left out from the judgment, from the order portion of the judgment by
Yes.
error. Full stop. It is submitted that an application is being filed to correct the said error as well. In the meanwhile, a report has been placed on record by the learned
State, my lord.
government advocate, which
Additional
shows that
advocates.
there is encroachment on 15.75 guntas of survey number 21/1 and 1.50 guntas is utilized as road connectivity for the encroachment. Full stop. It is submitted by the learned government advocate that details of the encroachers will be made available and that further encroachments shall be prevented.
Sorry for AG, my lord, instead of
Additional
AG.
advocate.
Additional advocate. By the additional advocate general. Yes. That list after 2 weeks,
2 weeks, my lord.
you've said that further encroachments will not.
That will take a precautionary, my lord.
Yes.
And we will instruct the concerned officer also by to note. And my lord, that's this with regard to this, the report who's on the encroacher, that report will be submitted.
Yes. You can also get instructions with regard to, if you're aware, you can produce a list so that they'll probably have to be further action they'll have to take in
They will
accordance
have
with
to take.
with notice to them.
That, Lord, it is after the order of the. Yes, my lord, correct. That
Yes.
also, my lord, they can. Lord, I have put it in my affidavit, my lord. Clearly, when the encroachment has taken place.
They should not be a backward entry of getting rid of the people. He has allowed them.
I am not allowed, my lord.
Easy way of getting rid of them. Their encroachers, if they have been allowed there, they have.
They'll be put
Yes,
on
sir, that
notice.
also observation, my lord, if it is there, the petitioner should not be an encroacher.
And God to that, I have no objection, but I don't know, he is in possession. How the state government can take.
But then they will have to restore the RTC to my name. I will take civil remedy. My lord, they can't keep the RTC
My lord,
there.
one,
And then, my lord,
my observation, my prayer to your lordship, my lord, kindly have it observations of petitioner also not been allowed the
Correct.
encroacher.
It is further submitted that the parties in this petition will not permit any further encroachments into the property in question.
very well.
Much.
All of you are bound.
Yes, my lord.
Yes.
my lord.
You cannot induct anybody. Yes.
So the connected case, my lord, the connected case, my lord, there's anything order that may be extended, my lord. Yeah, my lord.
Imprimatur shall remain in force. There are office objections. In the connected appeal, please clear the office objections as well.
Yes, my lord, please.
Wakalat of Advocate Abhinav R in respect of R1B, R2.
That is not responding here, my lord. Responding.
Please. Please see that the office objections are clear.
The respondent has to, my lord, complain, my lord, and the appellant then, please,
This connected appeal.
Yes, my lord.
please.
22, T.N. Vishwanath.
R7, R9, R11. Yes, 2 weeks' time is sought for to clear the office objections and to take steps granted as sought for.
23, Government Advocate.
Lord, we'll take first steps for completing the service on the respondents.
Yes, 2 weeks.
24, Singegowda. 25, adjourn. 26, Government Advocate.
25?
Yes.
Yes, we did not adjourn it. I said it will be called. Yes. Amendment of cause title. We can have it next week, because day after we have a separate combination.
Yes.
Can be someday next. 24. 24.
Government advocate.
But seek 2 weeks time to file better affidavit, man.
Yes,
We have sought instructions, awaiting instructions.
yes, weeks time, sir. Not for grant.
27, Basuraj. MS.
27. 2 weeks time.
28, BS Nagraj.
Maintainability of appeal. Is this the objection to with regard to maintainability? 10 lakhs does not exceed 10 lakhs. What do you say about the maintainability? On the value? What is the value of the appeal? Yes. Yes. It is submitted that the valuation slip shows that the total valuation of the appeal would come to more than 27 lakhs. It is further submitted that process has been paid. Yes, the office objections are therefore overruled. List for admission. List for admission after a week. Yes, notice is taken off. Yes.
29, Vishnu Hegde.
List after service objections.
Respondents, state minutes.
And all them, they have came back to India because they were in Karnataka, staying there. While returning, the mother refused to hand over the child back to the father. I bought the ticket for the son as well as the child also. They refused to restore the child. So thereby, my lord, I was compelled to file a petition for restoration of the child to the custody of the father. The office objection, there is nothing, my lord, where we have sought only the prayer is this, my lord. Primarily, it has been settled down by Honorable Apex Court also, my lord, where in such a situation, the child has to be restored to the father because he is a national, foreign national.
And I'm appearing for fifth respondent.
Mm.
That several cases were pending between the petitioner and the fifth respondent.
Mm.
Petitioner has not shown the intention to appear in all those cases by avoiding GNWC cases pending before the family court of Davangere and divorce cases also pending before the Davangere. Having knowledge and even having pleading in the petition, he did not appear. That is first aspect. That when the cases were pending before the Davangere, that has to be settled before the court at India. And that the Honorable Supreme Court has said that since India is not a party to Geneva Convention, court judgments are not binding on the Indian.
How is a habeas corpus maintainable at all? Why don't you file an application? Because there are cases pending between you. Could it not be filed as an application for guardianship?
I'll produce a copy of, I have already produced a copy of the Honorable Supreme Court. I'll also say that. What is my contention of my learned friend? My lord, what is dealt?
In normal cases, you're right.
Yes.
When there is deprivation, you can file it. In situations, but when there are several cases pending as against, as between you, is it not only proper that you approach the family court, and what prevents that exercise?
Yes, the question, two questions are there.
Mm.
The family court case questions where perhaps it is given to understand divorce petition also been filed by her. GNWC case, GNWC custody of the child.
Exactly. In such a case, why should there be a habeas corpus motion is the only question.
I will satisfy this honorable court where the apex court has taken a different view.
Apex court has taken.
Why,
such
I'm
views.
sorry,
sorry.
Yes, apex court has indeed taken such views.
Yes,
And in certain circumstances, they are warranted as well.
yes,
But in a situation where there are several litigations between the same parties
Yes.
before the family court,
correct.
and this is a part of the matrimonial dispute, why should a habeas corpus petition be filed? Why can you not approach the family court and seek a restitution of the child's custody in a proper custody application?
Correct.
All the contentions can be considered.
Correct. Similar situation, my lord, I'll produce. In fact, I filed a petition in Canada also. Canada court also directed.
Hmm.
This is aware of it that
Or the reason why you can file an application for custody before the family court.
family court custody, you lost my kindly see, as I already made a statement.
The question is this.
Yes.
Is the custody with the mother illegal?
Yes,
Or is it a custody which would warrant the exercise of the habeas corpus jurisdiction of the court?
correct.
In a normal case of dispute between spouses, the custody with the mother cannot be said to be so illegal as to warrant the high prerogative writ of habeas corpus.
Correct.
In normal situations.
I understand.
It is something which has to be thrashed out between the
Correct.
spouses with the least agony to the child.
My,
Bringing a child before this court. Well, in normal situations,
I understand.
the effort should be to avoid that.
Justified. Well, ordinarily, my lord, what your lordship is justified. The other question arises is, there is a child is of Indian, same national. That's right, where I can fight it out. When it's child is a foreign national, then what happens is a short question. Whether that court can decide, the family court can decide about it.
Why not?
That's the reason why the habeas corpus petition itself, the matter has been judged by. Now we'll take, you'll also take it up 2 days later also. I will argue the case on merit and let us see. My
Kept on merits, whether.
I represent Union of India, my
Yes.
lords. Now, in between husband and wife, my lords, they were married as a party.
Absolutely.
Lords, now when they have subjected themselves to the jurisdiction of the courts of India,
Absolutely.
lords, let them hesitate their rights before the JNWC petition already filed before my lords, Davangere court.
There is a custody.
There is a custody issue pending before the Davangere court. Instead of keeping this matter pending, my lords,
I will
take a parties can be relegated to family court at Davangere, wherein my lords JNWC 19 of 2024 is pending for a consideration. And
Correct.
both the parties are, my lords, hesitating their rights before the family courts as well.
Last time fixed date, we will finalize. I will satisfy this honorable court.
And that is what even, my lords, on the apex court.
Day after also, day after also, I am ready, my lord.
Day after we have a separate combination. We don't have this combination.
Yes.
That is what is the view taken by Honorable Apex Court, my lords, in 2019, my lords.
There are views taken
Yes,
this way
yes,
and that.
that
But
is
the
it.
issue is whether
Yes.
what the facts of the
Habeas
case
corpus
are.
is no, my lords, issue.
Whether in the facts of the case,
Yes.
habeas corpus is warranted or not is the only question.
Correct. That's all.
It is something which has to be decided on a case-to-case basis.
Lords,
Yes,
it
just
is the
justified.
consistent view of the Honorable Apex Court, my lords. Habeas corpus is not the, my lords, the course to issue the legality of the custody of the child.
Yes.
And satisfied.
you want
Last me fix a particular date, my lord.
We are only on the facts of this case and what the judgments say.
Yes.
Judgments are clear in as much as in a normal case of
I understand.
custody.
Yes.
There is no illegal detention is my respectful
Absolutely.
submission. Ultimately, the child is with the mother.
Whether the detention in the facts of the case is illegal.
Yes.
Yes, that's been dealt by, we will deal with it, my lord. Last me kindly fix a date, my lord, but
Yes.
one date.
Yes, please cure the office objections that
Yes.
have been.
That today itself I'll take steps.
Yes. Yes. Next, the
One
week
date.
after, the week after.
Lords, let the child celebrate the Diwali with my lord's, my lord's mother, and afterwards we'll come back, my lords.
Immediately after that.
4th,
4/11.
4/11.
You can move the family court in the meanwhile.
That will take.
Even they did not appear before the family.
Yes.
We'll have to see whether notice has been served and all that.
It is in their knowledge.
There's an
They have put it
application.
in the petition.
Application apparently filed by you before the family.
I'll do that.
Ask them to move it.
I will do that. We'll attend to that.
Then in that case, probably this will become infructuous by
Yes.
411.
Virtually, this has become infructuous now. Now at least they know where is the custody of the child, where is the child is.
No, as a matter of fact, if the mother is keeping the child away,
Yes.
then probably habeas corpus may be
Yes.
justified in some situations.
That's all.
Normal situations, it should be before the family court because the intention is that even production is more child friendly in family courts.
Correct.
When
And they are already there.
when the child is brought before this court, it creates a
Yes,
situation. of
traumatizing
avoid-
situation, my lords, to the child.
1.5 years old child.
We should not be, the
know,
child should
I
not be traumatized in family courts right now, at least in Karnataka. It appears that the child visitation rooms are
Rooms are there.
provided. All that creates a better atmosphere for the child to be brought.
Very well.
Anyway, yes.
30, Nagaya?
Office objections.
Filing objection to the application filed by the respondent for release of the amount.
The first one, I filed an application to release the deposited amount,
What is the amount deposited?
57 lakhs, 55,700.
Lord, we being the agreement of the order passed by the reference court
Hmm.
as against the award passed by the special LAO.
Hmm.
You have filed this appeal before your lordship.
Hmm.
They claims that in 2 acre 36 kuntas, they have planted 2,000 pomegranate trees and 2,000 drumstick trees.
Hmm.
The RTC reflects
Hmm.
there is no such a trees exist in the crop grown in the land.
Hmm.
And subsequently, after notification, it was RTC return saying that drumstick trees and pomegranate trees have been planted after notification. Notification of the year 2010. Subsequent years, RTC refers to the crop of the drumstick trees
Is
and
it only on that ground, the
yes,
trees and crops that the enhancement has been
no,
granted?
not at all planted earlier to
Is it only on the ground of the trees standing on the land that the enhancement has been granted?
this around only on the ground that compensation enhanced by the reference court.
One and two have initially
Survey number?
total compensation was
Survey number?
1 crore.
Survey number, my lord,
Wherein
sorry,
respondent number one, the
survey number
Award is in.
survey number 31/1.
31/1, Gulivasali village.
Reference petition filed by the first respondent herein, agreed by the total compensation granted by the special legal. Thereafter, the reference court has enhanced it to 2 crores, 30 lakhs, 800.
Value of acquired land is fixed at 1,40,000 per acre. Then additionally pomegranate tree and drumstick trees also.
Yes.
So therefore, with regard to the enhanced compensation on the land itself,
No, land has not been enhanced. No compensation has been enhanced to the land. They have enhanced only to the crops. Which is at order at page number 36.
rate is fixed by the SLAO is 95,520.
Please, madam, in respect of land is concerned.
Correct. That has been enhanced to
No,
1,40,000.
that has not
Has
been.
been, please see the order.
That is for, please, ma'am, that is 1,40,000 per acre from 98,500.
Correct.
Please.
With regard to that, you have
Yeah,
no,
yeah, yes.
no complaint. Therefore, it's only with regard to the
Even
trees
that-
that you have an objection.
Please.
Yes,
Resubmission. That portion is unread.
correct,
And
correct. Therefore,
record should come and both should be,
what is your application for withdrawal?
the withdrawal is seeking, since my son is studying MBBS, the money is required.
Only 50% is deposited.
50% is deposit. I'm seeking to release that 50%.
Percent of the deposited amount. Can
Even,
be pleased.
even if it is released, that much also. Even if you are succeed in the appeal later, then
That we, yes,
how do they, because they have utilized the money, taken the money, it appears that they have no other land than the property. So when they have, when they have,
very, very little chance of the appeal succeeding in full.
definitely no, my lord. I have 100% chance of succeeding in this appeal,
With regard to the trees,
that to the
You-
trees is
you
concerned.
don't
Trees.
have any
Solid.
serious contention with regard to the land.
Even that is land also we have disputed, saying that there was no reference for the last preceding 3 years of the registration authority in respect of land is concerned.
Writing to the cards and also
Yes. It's got to be please. To take your- with regard to the- use of 50% of the 90%. On condition. Yes.
For the learned. Counsel for appellant as well as respondents. And I number. 3/24. As per the submission of learned counsel for appellant. Serious dispute is in respect of 2,400 fees. Said to be situated in acquired land. And it is not disputed that exponent is the owner of the said acquired land. Under these circumstances, looking to the contention of the exponent stated in the affidavit, it is just necessary to release part of the amount deposited by the appellant. Accordingly, application by dia number 3/24 is partly allowed. Permitted the trial court to release 25% of the deposited amount in favor of respondent and due identification. And also an execution of the indemnity bond for the state of
50%. Education required,
50%
medical.
of the-
25% of the deposited amount.
50% of the-
By-
50% of the deposit, not the entire amount. 50% is deposit. So 50% of the,
50% of the deposit.
My lord, by,
50% of the deposit.
please, my lord.
Execution of the
50% of the deposited amount on execution of indemnity.
With a condition to furnish security for that amount.
The indemnity bond and execution of the indemnity.
Please.
All for the TCR.
And the rest of the amount we have granted, we have obtained stay from your lordship, will be continue.
Yes. The
That's all.
imprimatur will continue.
Leaves this matter of receipt of TCR.
It's not yet done. Fine, quit item.
Even admit also. Admit and call for the TCR.
31, Cyril Prasad Payas. PF.
For the appellant, my lord, in 31, my
Yes.
lord. 31-1, my lord, my learned friend is representing the,
Corrected, madam. So I'll take notice in respect of respondent.
yes, ma'am.
Yes. So and so learned counsel takes notice on behalf of the respondent in
One.
MFA 3286 of 2024. Yes, you are already appearing for
Yes,
the,
I'm appearing in the
yeah.
other matter.
yes. Appeals have been admitted.
My matter, my lords. Model is that.
Interim order has been entered.
Yes, admit the appeals, call for the trial court records. Interim order shall remain in force, list immediately after the,
There is a
Uh,
delay of 15 minutes.
oh. In which one?
First.
First one, in mine.
32,
Yes. The delay can be condoned. Having heard both sides, the delay of 29 days in filing MFA number 3286 of 2024 is condoned. Admit both appeals, call for trial court records, list after the trial court records are received. The interim order granted earlier shall remain in force till the next date of hearing.
It is enforced until further orders.
It's enforced, already enforced, so
It is
don't
for-
say
until
anything.
further orders.
So don't say anything, yes.
32. Siddharth Padmanabh Desa.
Please.
This honorable,
In service of notice R1, R2.
but they have been served, they were heard.
But my statement is ready, my lord. I'll be filing it today.
But there is some urgency. I had also moved it during the vacation because this honorable court granted me an interim order on 19/9/2024. Lord, the interim order was that I should be allowed to participate in sports category. Today, my lords, I am not being allowed to participate in the mop-up round in sports category. I am only being allowed to participate in my original category, which is 2A, rural. The interim order specifically permits me to participate in sports, and my lords, it comes to an end today, the mop-up round,
It is already over. My lord,
11 PM tonight.
Just a moment, just a
Yes,
moment.
yes.
Petition seeks prayer to be considered for admission to MBBS course in the sports quota. Eligibility is prescribed in the rules. Amended rules, the petitioner claims that he is satisfying the requirements. Objections on part of the authorities is not considering is that petitioner has not participated in two sports competitions in the specified years. Requirement is that out of two participations, the best shall be considered. There is no bar or prohibition for consideration of a candidate who has achieved in one competition only during the relevant year. Notice returnable. Since the petitioner has made out prima facie case, subject to the reply that may be filed by the respondents by way of ad interim relief, it is directed that a seat in the sports quota, if available, shall not be allotted to any student.
yes.
And further, that the petition shall be permitted to participate on merit in the mop-up round in the sports category. Whatever of his objections left out shall be removed. Two best or two highest achievements in sports competitions during the year specified in clause 1 shall be taken into consideration. However, only one best or higher achievement shall be considered in a financial year. Two best or two highest in sports competitions during the year specified.
Lord, annexary, my lord, as far as the allotment of seat is concerned, but in mop-up round, my lord, all seats get, my lord, merged. But we have, my lord, allotted one seat and we have kept it vacant. We have kept it vacant, subject to the result of
So
the.
what about the other part of the interim order to permit him to participate in the?
Participate on his merits, my lord, he could have. He
What
could have
about-
participated.
No, the direction is this.
Yes, because there is no, my lord, there is no quota, sports quota in the mop-up round. Because
Mop-up round
everything
is
gets,
the,
yes.
is the general
General,
mop. He
everything
has been
gets.
permitted to participate
He is
and
per-
one
he is
seat has been
permitted to
kept apart.
Mop-up round yet to commence, but it has not been commenced. Second extended round, but there was no quota there also. Nevertheless, there were only 7 seats for medical. So one seat we have kept it as it is. We have not allotted, we have kept it for the purpose of this case. If petitioner succeeds, and there are other requirements are there. If he succeeds, suppose if he succeeds, there are others who are, they have not,
Who
we
may
have
have
to, yes.
the-
So therefore, I'll file my counterment today. It's ready, my lord. The officer is not there, my lord.
May I, my lords? The last sentence of para 7 says,
Hmm.
I should be permitted to participate on merits in the mop-up round in the sports category. Lord, what happens is if I participate today, if there are 3 colleges, I will have choice of choosing one among the 3. If they, my lords, say that they have kept only one seat vacant, then, my lords, I don't know in what college I will get that seat. A specific interim order is granted in my favor that I should be allowed, if there are 3 MBBS seats under sports category today available under 3 different colleges, I will have the ability to choose one of them. That's the order that has been granted. But they should give me the benefit of that
First
order.
thing is, my lord, regarding the eligibility itself. Eligibility, my lord, he has not he has participated only one, this thing, the government.
The
has-
3, in the 3 years, in the past 3 years, only one.
Only one. Only one participation. Eligibility itself is not there.
Highest achievements in sports
They have challenged the rule itself now.
shall be taken into consideration. However, only one, there has to be 2.
My lord, the rule is, my lord,
Best.
Anakshariya is the rule. Your Lordship, our rule has been amended this year. He has, my lord, last year, he took a seat in Ayurveda. At that point of time, my lord, he was eligible because this rule was not amended. This year, rule has been amended. So he has challenged the rule now. If the rule goes, my lord, he'll get it. That is what he says.
My lord, I have of course, my lords, challenged the rule, but The
Even
interim order,
without the challenge, according to you, it is.
please note, the
it
interim
would be-
order was granted on that basis because the
Hmm.
rule does not say
Hmm.
I have to participate twice. It only says two of the best if I have played 5 sports.
Of the two best or two highest.
Two best or two highest. It does not say I could have done 3, I could
Not
have
be
done.
one,
Lords, that language is not there here in the.
not clearly worded. So you can-
They
could have-
rule, my lord,
Therefore,
I ask, my lord,
all you have to say is they must participate in two.
my lord,
That
in
was
fact,
not the intent also.
their-
Lords.
our intent is, my lord, they have to participate in how many ever competitions they want in a financial year, only the best will be taken.
Hmm.
And 3 financial years certificates have to be filed.
Hmm.
In those 3 financial years, the best 2 will be taken and aggregate will be calculated.
So there has to be two according.
There
to
has
you.
to be 2.
Lord, that language is not there that there has to be 2. Therefore, Lord,
My
it's a
lord,
beneficial
in fact,
legislation.
If I read.
If I have played one unique sport and they don't deny that I have played that sport and I have secured good marks in that sport.
What is the sport you have played?
Lord, I have played cycle polo.
Our difficulty is, my lord, on this very ground, we have, my lord, many applications were rejected. They might be even higher in the merit also than the petitioner,
Therefore, let
because they have
them.
reconciled with the fact. They are not, merely because he has filed it, I can't deny, my lord, the opportunity to others also. Merit should be the, my lord, the
Lord.
criteria.
On that, my lords, my respectful submission is, I see what my learned senior friend is saying, but today there is an interim order in my favor. Let that work itself out. Of course, my lords, your lordship will finally decide. And at that stage, if this benefit is to be given to the others, then the entire exercise will have to be opened up, which is why, my lords, when this honorable court granted me an interim order, that was not the interim order. The interim order was in the seats that are left, you participate. That was the limited order. The order was not to upset round 1 and round 2, which have already taken place. Today, my lords, they are not allowing me to do what the interim order grants, which is if there are 3, let me select one. Of course, my lords, it will be subject to what your lordship will finally
But
decide.
I may have to get back to, my lord, how many, because only 7 seats in medical, my lord. How many seats are gone on in the previous, the round, my lord, I have to see.
Lord, my instructions are that.
As a matter of fact, there's only one seat. That is
No,
the end of it.
Lord,
There is no difficulty.
Lord, from what I know, there are 4 seats under sports category still open. 3 seats are open. There were initially 7. Out of the 7, 4 have been selected. 3 under sports category are still open. It is still 11:59 PM tonight. Therefore, my lords, during the vacations also.
Also, Lord, these results are being, my lord, generated for others. That can't be stopped, my lord.
No, my lords, I should be allowed to participate in sports category and choose one among the 3 if 3 are
No,
available.
the counseling process is over. Results will be announced today.
No, mop-up round is open till tonight, 11:59 PM.
But lordship, I have this at 2:30, I just,
Please.
because mop-up round according to me, my lord, has not happened yet.
Has not
It
happened.
has
yet.
happened yet.
Maybe the option in the mop-up round has to be given.
Option
Option entry has to be given tonight, your lordship.
I will just see, my lord.
Great.
So there is an interim order and how best it can be complied with
Yes,
will be the
madam.
question.
Great.
Final hearing, number 33, 34, 35 adjourned. 36,
35 is also adjourned. 35 is not adjourned.
35.
We were there, my lords.
35 is not.
35.
I beg to appear for the contesting respondent.
What is this about?
Well, this arises out of the Inam's Abolition Act. And in fact, my learned friend has placed 2 memos on record.
Yes.
And the finding of the learned single judge is also that this very order of the Special Deputy Commissioner for Inam's Abolition, dated 12/7/1999, that very order has been challenged in several writ petitions, upheld by several learned single judges, writ appeals dismissed, 3 rounds of special leave petitions dismissed in the Supreme Court. And this is the 4th set. So they're all squarely covered, my lord. In fact, those orders are all placed before my lords by way of memos.
We stand on a different footing in the sense that these are buildings and therefore exempted from the act. That's one point. The other point is this division bench of this honorable court had permitted me after my petition was filed. The matter was remanded to the to the authorities. The authorities upheld my contention and my appeal was allowed. Subsequently, the writ petition was filed. In this writ petition is dismissed, against which I have now come up before my lords. I thought we wanted some time, my lord. I never knew that it is being heard today.
It is listed for final hearing. My instructions are, my lord,
I'm not saying.
these are appeals of 2018.
Not saying.
There is an,
It's 11:52 today.
and my lords, there is an interim order of 19th February 2020, which is operating against us, despite the order attaining finality right up to Supreme Court in 3 rounds.
I also have.
Despite
some
that. And
personal-
all the contentions that my learned friend urged, even that question of section 9 and 12, they are also raised, argued, concluded.
No,
I had the good
will-
fortune of appearing before the Honorable Supreme Court.
It'll take some time. Any short accommodation, I'm not going to, I'm not going
I
to.
have all the time today, my
No,
lords. I have come all the way from Delhi for this.
Sir, I wish my learned friend had intimated me. No, I was not, whole of this vacations, I was down with the viral also. That's the only reason. Otherwise, I wouldn't have asked for time. I only request my lords for some short accommodation this time. I'll go ahead with the matter the next. I will not keep my friend take
Your lordships.
as on this date, I will not.
Your lordships also have rich experience at the bar. We will never come in the way of a learned colleague's request, my lords. The only anxiety is, if your lordships can please have it on the 28th. 28th of October,
28th, Monday,
Monday.
2:30.
Please.
And my lords, since your lordships have taken an idea of what the subject matter is about, the service and all that may be dispensed with, because what happens is the office noting in the cause list, the respondents who are not served are appellants in some other appeal. So there is no difficulty. And your lordships may hear it finally.
If services is complete, then it can be
What happens is,
substantially complete, it can. be
it is.
difficult.
We have checked up, my lords. My learned friend has spent
Sir,
considerable time.
I am concerned. I don't think I have any problem on that, any issue on that one.
I think we have checked up, my lords. They are either appellants in the connected appeal or respondents.
I'll confirm.
And they're
I'll-
represented.
If as a matter of fact, they're represented,
Yeah.
let that be recorded here so that on the next date it won't.
Can I indicate, my lords?
Has anybody died? Deceased R5.
Deceased R5, R5, I and J.
Yes.
Your lordship will see,
20.
yes, my lords, from 3rd of June 2021, more than 3 years ago, they have not taken steps. And the brothers and the siblings of R5, I and J are represented by Mr. Lokesh. Your lordships will find on the right-hand column, Mr. K. Lokesh.
We represent.
He's there. And in any case, my lords,
You can represent the,
We will take notice.
You can take notice.
Except notice for the very same parties are there, my lord, we have.
yes.
and in any case, my lord, let me clarify. This R5 is a person called Venkataraju, who has nothing to do with survey number 134, which is the subject matter of the writ appeal. So they are formal parties.
No,
The-
anyway.
And in any case, they are there. In any case, they are there.
You know,
Yes.
connected matter, we are there, we need to accept the notice.
Please record that R5 ING. In 35, there is no issue. 35.1
Also, there is no issue.
memo for dismissal filed by advocate for R1 to R3, memo dated, there's no issue. Then 35.2, the issues with regard to R5 INJ.
My learned friend, Mr. Lokesh, I think appears.
Mr.
Yes,
Lokesh,
yes.
learned counsel takes notice.
For R5A, B. and-
R5 INJ.
No, I and J.
And undertakes to file wakalat. Then on filing of wakalat by advocate M.A. Appaya for R5.
Instead of Mr. Appaya, Mr. Lokesh has filed.
Yes,
That is complied with.
Mr. Lokesh has filed wakalat in respect of R5 A2H, K2N and Q2S. The said office objection is therefore overruled. Then 35.3, non-furnishing of R13. Hmm. 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 R13. R13, R14, 20, R24.
Your lordships might take it, they are all formal parties, my lords. They have nothing to do with the subject matter. The contesting respondents are represented by us. Your lordships may,
Please make the verifications. We'll list it on 28th. In the meanwhile, please see that something is done in respect of these unserved persons. Otherwise, well, if they say that they are not affected parties, you will have to take a call on that. It's your appeal. Yes. That's it.
yes. And there's one more thing, my lords, that number 3 in 35.3, appellant number 1, he is a respondent in 35.2 and he is represented by counsel. So the LRs are represented by counsel.
That can be in respect of the appellant. Yes.
Would the lordships kindly indicate it's for final hearing, my lords?
Yeah, please, ma'am.
Yes, for final hearing on
28th, please.
2:30.
Please. Yes.
Grateful, my lords.
Grateful.
For the appellants, my lord, they apply for short accommodation.
What is this about?
It's about acquisition of land, VDA, acquisition.
Challenging
Issued by BDA.
the acquisition initiated for Nadaprabhu Kempegowda. Lord, he accepts the consent compensation. Lord, then thereafter, after 6-7 years, he turns around and comes and challenges the acquisition proceedings.
Short.
Consent acquisition, and even otherwise, my lord, the division bench of this honorable court has upheld the acquisition proceedings and my lord has issued certain guidelines. Now he has accepted the compensation. Virtually, my lord, if he wants to go back on to the consent compensation also, Lord, then he'll be left with nothing, Lord. I'll be compelled to pass a general award, Lord, which will be much lesser to it. But it's they who are.
This all court has upheld the acquisition notifications. Similar orders may be granted to me, relief also to me also.
Petitioner number 1 Hanumaya has
Yes, no
acquiesced
more.
in the land acquisition and was a party to a consent award.
Yes.
Petitioner number 1 and other legal heirs as well as are therefore stopped from raising a challenge to the said land acquisition. That is the finding. Yes, what is this?
That's.
This all court division bench have upheld the acquisition notification
Mm.
with liberty to the parties to make a representation.
Mm.
If there are any developments or anything, they can consider it. When similar relief may be granted to petitioner for this appellates also.
Just a moment, just a moment. The above appeals by the BDA are allowed. Order number so and so passed by learned single judge connected with petitions are set aside. Orders passed in writ petitions which are decided placing reliance on order dated 11/7/2014 in 32186 and other are also set aside. Preliminary notification, final notification are upheld with the following conditions. Landowners excluding site owners who are seeking dropping of their lands from acquisition on the ground that their lands are nursery lands situated with greenbelt, etc. That similarly adjoining lands have been either left out, deemed fit necessary in support of their applications. BDA shall consider each of the applications to make an application seeking for dropping of their land. That cannot be in your case because you've already accepted the consent compensation.
The civil suits are pending filed by the daughters. Claiming shares, that issue is still pending. Whether the consent given by the father is valid or not is still adjudication. So many.
That was, those were applications seeking dropping of the lands from acquisition.
Correct.
Now, in a case where
No, we
you
have not
already,
accept-
the predecessor has accepted the consent.
We have not received the compensation. We have not received the compensation. It appears they have departed before the civil court. If I received the compensation, I have no case at all.
No, even consenting to the compensation is good enough.
Yes.
Sign the consent award R3.
Yes.
Agreement dated 6/12/2012.
Yes.
Compensation amount is 1 crore 70 lakhs.
Yes.
6 acres, 13 guntas. Thereafter deposited with the court,
Yes.
since petitioner did not come forward to take the amount.
There is a son.
Now, how can you say that it should be dropped?
Nada.
You are legalized of that person who has accepted the compensation and who passed away
My
thereafter.
father also filed a writ petition. Along with the father, they filed a writ petition.
How can you?
Uh,
If you had not, this consent award was not there, then what you're saying is correct, it could go with this.
There are several writ petitions, writ appeals also identical, madam, are clubbed in different directions are issued by the Honorable Court.
No, is it your contention that in these cases also,
Yes,
there are
madam.
persons who
I-
are
I will-
party to
I will
consent
make-
awards?
We'll make a representation, let them consider and pass appropriate orders.
Is it your case that in these writ petitions, in this batch of writ petitions, there were cases where consent awards had been passed and amounts deposited in court?
No,
Uh,
no.
If it is not, then this judgment cannot be applied.
madam,
You
my-
have such a case, please get
But-
instructions on that.
Lodge,
If
I'll,
you
I'll,
have such a case, then we'll
I'll make,
consider, not
I'll make a
otherwise.
submission on that. There were more than 250 writ petitions filed,
Correct.
out of which, my lord, we had filed 215, 250.
Hmm.
During the pendency of the writ appeal, my lord, many of them, including my learned friend,
Hmm.
has withdrawn the writ petition and said,
Hmm.
no, we will go approach the BDA for consent compensation.
Hmm.
That was permitted by the Honorable Division Bench. Here in this case, what has happened is, kindly see Annexure R8.
Hmm.
Now there is a possession which he has handed over it to me.
Hmm.
Annexure R8 is the possession matter on which he signs.
Hmm.
Now there is no question of, my lord, once the land vests with the state, my lord, there is no question of deletion of that land from the acquisition proceedings.
My,
So the only option, what they have to now is, my lord, they'll have to accept the consent compensation, which is more beneficial than what, even if the land is deleted from the acquisition proceedings. My respectful submission is, my lord, it is that way. Why, my lord? Because 1 acre of a land, he wants to seek a deletion of a land from acquisition.
Hmm.
For a moment, let's assume that it's deleted from the acquisition proceedings. 1 acre of a land, he has to develop it because it comes within the developed area. He cannot have an agriculture activity. For a development, my lord, he has to straightforwardly give me 45% as my lord, a civic amenity, roads and open spaces. What is left out with him is also 55% of the developed sites, out of which, my lord, he has to spend more than 5 crores, or 5 to 6 crores for even only seeking those approvals and all those things. That are the charges that they incur. Not here, straightforward, we are giving them a 40% of the developed sites, which is much more worthier than even if he own develops it. That is what, my lord, we have canvassed. Even, not they'll not
The
get.
question is only this.
yes,
After accepting the consent compensation and the amount being deposited in court and after handing over the site, you cannot seek dropping
that's-
from the,
that principle, appropriate and appropriate applicable to that, I'm aware of that.
Cannot.
my lord. Question
absolutely.
is, my lord, my friend says, can possible to allot the developed sites? As is accepted in so many cases, I also argued before the Sun Court and accepted. I will take instructions. If they are willing to take developed site, my lord, then it will go over if they are going to.
But it
give.
is a part of the consent award. The developed site is also a part of consent award.
That's all there is to it. This judgment may not be applicable in that sense because if you had never accepted anything, then probably you can say that it should be dropped. Otherwise, you cannot. Yes, list after 2 weeks.
Which may happen next week, my lord, because we are now in the verge of completion of this layout. Not next week, any day.
25th,
Please.
24th.
How?
Can we have it on 24th?
Please.
37, Harish Bandari.
Not counsel for the appellant seeks time to get instructions. It's on 20.
For the appellate, your lordship, for corporation. The short question, your lordship, in this case, your lordship, whether the second writ petition is maintainable when with the first writ petition was dismissed based on the ground of becomes infructuous.
Just a
Your lordship, first, your lordship, I kindly get it to page 41, your lordship. That's in Kannada. Your lordship, in that, your lordship, a revision petition 517. Your lordship, get it typed page. From page 60 onwards.
Yes.
So in that, your lordship, revision petition 517, 2012, your lordship.
Yes.
Along with other matters, your lordship, where a corporation has challenged the grant of permits, either renewal of permits, your lordship, before the tribunal. Tribunal has set aside all these renewal of permits, your lordship, by this order, 18th April 2015.
Just a moment. On 18/4/2015.
15, your lordship.
Hmm.
So renewal of permits has been set aside by the tribunal, your lordship, batch of matters, your lordship. In this, your lordship, 517 is the subject matter in this writ of
517, yes.
517.
Petitioner allowed. Impugned order mentioned in the above table below made by first respondent authority is set aside. PA order dated 9/4/2012 is set aside. Which is that RTA order?
RTA orders, your lordship, RTA orders are not produced, your lordship, but that your lordship, they have extracted, your lordship, that at page 45, serial wise, they have mentioned, your lordship. In translated page, your lordship, translated page 65, your lordship, serial number 2. That is 517. Permit number 71/99/2000. And 2000 lordship.
Serial number 23, subject number 60/2009-10.
Lordship, 63, page 63, your lordship, got it?
No, this is the impugned order.
No, page
Impugned
number
order-
63, page number 63, serial number 2 is the subject matter in this now.
Correct.
Yes.
Hmm.
There, your lordship, RP 517,
Same.
same.
Serial number 23, subject number 60/2009-10 dated 9/4/2012.
Yes.
That is the RTA order which has been set
Yes,
aside.
exactly.
Hmm.
One of the RTA order challenge, your lordship. That was set aside, your lordship, by the tribunal. A batch of matters, your lordship, it's one among them.
That was a renewal order.
Renewal orders, your lordship. In fact, your lordship, we have challenged, your lordship.
Hmm.
The very permit is not sustainable for the reasons, your lordship, which violates various schemes, as well as the the authority which has already granted the permit has no jurisdiction. Because the ground, your lordship, the jurisdiction issue was, your lordship, since the major portion of the route traverses on the Bangalore urban, not under the rural. So the authority has no jurisdiction to grant the permit. Then, your lordship, one of the scheme that is called one Anakal scheme was existing. That Anakal scheme does not save the permit, your lordship, for the reason, your lordship.
Existing permits are also not saved.
No, that because
Okay.
Anakal scheme, what it's interstate agreement, your lordship, between the Tamil Nadu and Karnataka, it saves the permits. But whereas this is the intrastate permit. So it is also not saved. All these conditions we have taken.
State permits are not saved by the scheme.
With these conditions we have not taken, your lordship. Ultimately, it was renewal was set aside.
For all the above reasons, it cannot be considered that the permits under the revision petitions are saved permit or exempted permit. Therefore, second respondent is not entitled for the benefits of saved permit or exempted permit.
Yes.
The said point is answered in the negative. Second respondent is observed so and so, order made by petition so and so, control is retained finality. Permits of second respondent cannot come out of the above accepted routes in the permit or overlap the nationalized routes. Hence, said permits cannot be renewed for further period, for all cannot be said to revise the subject.
Your lordship referring translated portion.
Yes, yes.
Then, your lordship, this has been challenged by the various petitioners, as among these petitioners also. That petition, your lordship.
25.
That writ petition, your lordship, the first petition is the case Srinivas in the instant case. 25524 and 255 up to 2006, Your Lordship. Your Lordship get the preamble portion, Your Lordship, revision petition number 517, Your Lordship.
517, 515,
Yes.
513.
So this is 517 is the subject matter now. So this matter, Your Lordship, that order that, Your Lordship, in the meanwhile, pendency of this writ petition, a notification was came to be issued by the state, dated 5/8/2015, withdrawing all the notifications which saved the permits. Periodical saving clauses was given to all these illegal permits. On 5/8/2015, state issued a notification withdrawing all the saving clauses, saving permits. So when that notification came to be issued, this court passed the order, it becomes infructuous. Since all the savings has been withdrawn.
All the saved permits were
By virtue of various notifications. that
correct.
has been
All those notifications were withdrawn.
withdrawn 5/8/2015 notification in a single notification.
How will that?
Then Your Lordship, that is subject and Your Lordship subsequently that has been challenged. Again, it was remanded to the, that is another aspect, Your Lordship. Then 5/8/2015, by that time it was, since this notification issued, this court passed the order saying that, Your Lordship, in of the subsequent para 2, Your Lordship, in of the subsequent notification, nothing further surveys for consideration in these petitions. Consequently, the petitions are dismissed as having become infructuous with the liberty to the petitioners to challenge the said notification.
Correct. Therefore, they could have challenged the 5/8/2015.
They have challenged the notification.
But not this revision again.
Yes.
This order in revision is now again challenged.
Again challenge. That is what, Your Lordship. That, Your Lordship, that again, Your Lordship, that is the other single judge order, Your Lordship. Your Lordship will get it page 19, Your Lordship. The party, Your Lordship, K.R. Srinivas Reddy, Your Lordship, it's the same party. And Your Lordship, page 20 preamble portion, you can come to the preamble portion, Your Lordship.
Yes, yes.
The very same RP, revision petition 517, has been challenged, Your Lordship. There, Your Lordship, what the single judge passes the order to consider the things on merits on other aspects.
Paragraph 5 says, being aggrieved by the said order, petition along with 2 others filed writ petition before this court, which was disposed of on 28/2015, observing that the subsequent to filing of the said writ petition, the state government had issued
Yes.
further proceedings, nothing survived, as having become liberty was given to the petitioner to challenge the said notification.
Yes.
Thereafter, petitioner along with others challenged notification dated so and so, and granted interim order permitting petitioners to operate their buses on producing relevant evidence. Said writ petitions were disposed of on 30/5/2017. Thereafter, state government had issued notification dated 28/9/2017, which is with regard to modification of several schemes, including Bengaluru and BTS scheme. But since the permit of the petitioner was set aside by the impugned order Annexure B, but at the same time as per notification, those permit holders who are operating as on 14/1/2002 are exempted from the said scheme. Question that would now arise as to whether petitioner is entitled for renewal of permit. It is in this regard submissions have been advanced by the respective counsel.
In the similar circumstances, Your Lordship, one among the other, one of the operator, sorry, Your Lordship, I have to miss the copies now, I have one copy now. In the similar circumstances, he has filed another similar
Writ petition, second writ petition.
second writ petition. Then this court, a single judge observed, Your Lordship, even if the position, since every order passed in the case is so and so, challenged by the writ petition is disposed of. Another writ petition of the present nature assails the same order would not be sustainable. However, petitioner would have the liberty of either seeking review of the earlier order or file an appropriate application in accordance with law. Your Lordship. Similar somewhere missed, Your Lordship, in my file.
Who appears for the second respondent? No appearance.
He has served and he has not represented, Your Lordship.
Yes.
So my submission, your lordship, he would have been either filed a review petition or any other mode of lordship, instead of filing the second review petition on the same cause of action. In the meanwhile, lordship, the authority
Same.
taking the order by the second writ petition, very hurried manner, renewed the permit. Of course, your lordship, later stage, I brought it to the notice of the court and it was stayed. And it's very hurried manner, he was very, he proceeded with the secretary at his chamber without placing the subject before the authority.
Otherwise, they would face contempt. Otherwise.
In
they
fact, your
would
lordship,
face-
the court was about to proceed with the contempt, then your lordship, he has apologized.
The contentions of both sides are left open. Order dated and revision petition is set aside. Could not have been done. Yes. We don't have the assistance of a counsel for the second respondent, but is this not the proper procedure? Because once it is dismissed as infructuous, saying that nothing survives, and liberty is granted only to challenge the notification. The second writ petition could not have been filed without at least getting the earlier judgment reviewed.
Review.
It could have been reviewed and stated that because of these circumstances, it has to be considered afresh and be done. But without that, this would be the correct position. Very order passed by the KSAT was challenged to the writ petition is disposed of. Another writ petition of the present nature to assail the very same order would not be maintained. It appears to be the correct position. Without getting that reviewed or permission being granted to challenge it by that court, would not have been done. We'll say the same thing. We'll say that.
Yes, that's
make
a
note
lordship.
to him to. You say, brother. Is that yes, the persistent? This appeal is filed against the judgment of the learned single judge in WP 12077 of 2018. It is submitted by the, we've heard the learned counsel appearing for the appellant as well as the learned counsel appearing for the first respondent. Though notice was taken out to the second respondent and was duly served, there is no appearance for the second respondent before this court. It is submitted by the learned counsel for the appellant that the second respondent had filed writ petition number 25524 of 2015, challenging the order passed by the State Transport Appellate Tribunal on 18/4/2015 in revision petition number 517 of 2012. The said writ petition was thereafter dismissed as infructuous on 28/2015 with liberty to the petitioners to challenge the notification dated 5/8/2015. It is submitted that the said notification had been challenged by the petitioners. However, a further notification came to be issued on 28/9/2017. Modifying the Bangalore and the BTS scheme and exempting permits which were granted, permit holders who were operating as on 14/1/2002 from the said schemes. Full stop. The petitioner thereafter, the second respondent thereafter filed the present writ petition, that is WP number 12077 of 2018. Again, challenging the order of the Karnataka State Transport Appellate Tribunal dated 18/4/2015, passed in revision petition number 517 of 2012. After considering the same, the writ petition was allowed, setting aside the order passed in revision petition number 517 of 2012 and directing the parties to appear before the first respondent on 3/9/2018 and directing the first respondent to consider renewal of the permit within 1 month from 3/9/2018. It is submitted by the learned counsel for the appellant that in an identical matter, another learned single judge of this court in WP number 14641 of 2018 had considered a similar matter and held that since the order passed by the KSTAT had been challenged in an earlier writ petition and the earlier writ petition stood disposed of, another writ petition challenging the very same order would not be maintainable. And the petitioner therein was given liberty of either seeking review of the earlier order or filing an appropriate application in accordance with law. Full stop. Having considered the contentions advanced, we notice that in the instant case also, the order passed by the KSTAT on 18/4/2015 in revision petition number 517 of 2012 had already been challenged in WP number 25524 of 2015. And they said writ petition had been dismissed as having become infructuous, with liberty to the second respondent to challenge the notification dated 5/8/2015. The second writ petition, which was filed without any review being attempted of the earlier order of dismissal, therefore, according to us, was not maintainable. In the above view of the matter, the order of the learned single judge shall stand set aside. The second respondent is set at liberty to challenge the earlier order dated 28/2015 by seeking a review of the same or to file appropriate applications in accordance with law.
Good.
The appeal is disposed of as above.
Good.
38 adjourned, 39 Tanmati EI,
21 writ petition. Please do. Where is the petitioner? Can we?
One submission, my lord, similar matters have been pending. It may be connected with those matters and called together, my lord.
Rules were framed and act was amended. A new act came into force. In the new act, my lord, consensual agreement is one of the modes of, my lord, the admission. Either, my lord, the consensual agreement or, my lord, through the normal course. In consensual agreement, my lord, the fee will be fixed not between the,
Correct,
by
correct.
consensus.
Then the other questions don't have to be
That
gone.
doesn't, my lord,
The expenses and the
nothing will come. The
calculations don't have to be gone.
calculations don't apply, and even if the committee fixes the fee also, that doesn't apply when the consensual agreement.
Correct, correct,
My lord, but
Is the
in-
short
in
point.
fact, there is a fee regulatory committee
correct.
which fixes the fees and
Correct.
they
The
ensure.
fee regulatory fee,
Committee.
committee fixation will not apply when there is a consensual.
Consensual, yes.
Therefore,
Here
that does
also-
not have to be gone
Please,
to
please.
it all.
Yes.
And in fact, when the consensual agreement, once they've agreed, they cannot surpass that amount also. They're bound by it. The state will not allow them to charge excess
No, what exactly was the challenge? The challenge was by a student
by student
as against the agreement.
as against the validity of the consensual
The
agreement
agreement.
itself.
That has been upheld
To quash the consensual agreement. But this,
to quash the agreement.
quash the agreement. And consensual agreements, my lord, year to year, my lord, they're
Correct.
No, once in
correct.
3 years.
once in 3 years.
Do you have a copy of the judgment? of
My
the
lord, I
Supreme
have a
Court?
copy of the consensual agreement of that year. I'll make another copy and
Yes.
submit to my lords.
No, do you have a copy of the judgment of the apex court? Or can you give us the number by which
lord,
you
that
said
is,
it has been upheld?
My lord, I'll pass it on, my lord. That is TMA Pi Foundation case.
Okay.
And then Inamdar case, which
And Inamdar subsequent.
So, but this appears to be a challenge in the year 2021.
21.
21.
20. Lord, now I see whether
Now
that,
this year there is a new consensual agreement.
So this would,
basically the terms and conditions remain literally the same, my lord. Only the fees
Fee, my lord,
will be,
no, we are only worried that the petitioner is not.
not there. That's the reason.
The petitioner is not represented. We can list along with the connected matters.
please.
Will you give a list of the connected?
I'll pass it on.
Yes,
I'll do the next.
yes, it is submitted by the learned government advocates that the challenge is against a consensual agreement entered into between the management and the government. And that nothing. survives
I'm
for
sorry, my lord.
consideration.
That's a PIL.
That is a public interest litigation.
Oh, will not come. here.
That is before the,
So we'll consider this on the merits.
yes. So should have
We
some
like to hear the petitioner's counsel.
some other day.
Shall we make an attempt after lunch?
Please,
Today we may be free after lunch. We may
my
not
lord,
have
this
any.
matter may have to be heard.
We'll hear it because the only aspect is the difference between the enactment here.
May I request, my lord, to be taken up next week? The point is this, my lord, but may I request my lords to take it up next week, my lord, on any date?
Speak your lordship, have it, so that.
If there are any petitions pending on this.
My lord, that is a PL. Sorry,
It's a PL, but
That's
the.
Yeah, we
challenge-
can't.
that's a PL.
Then is it better that this goes there as well?
My lord, that I
Maybe
leave it.
better because this is along with two benches.
There,
need
my lord,
not-
the sections, section has been challenged. Here, nothing has been challenged.
No, here also, section 4 has been challenged.
If there is a challenge
It is.
and it is pending before the Chief Justice Court, then two benches considering it and
Please.
the possibility of conflicts being there,
I bowed down. It may be sent there.
let it be to go before the, please give the number of the PI.
I'll do that.
It is submitted in the above view of the matter, and since a public interest litigation is said to be pending with identical prayers, we are of the opinion that the matter has to be heard together. Place before the registry shall place this matter before the Honorable the Chief Justice for orders. If the number can be given, we'll place it before the
The
registry.
prayer is, the prayer, my lord, he has not questioned the rule as such. He
Only
questions,
the-
he
only-
questions the consensual agreement framed and entered into under the rule.
Only that.
Only that. Lordship, kindly see, my lord, the third,
If there is no chance of any conflict, then we'll hear it. We
yes,
don't have any
that's,
decide.
that's the reason, my lord.
Lord may hear it.
Either way,
Lord may hear it.
difficulty in hearing it. We don't want any conflict of orders to happen. That is all.
Yeah.
Please look into it and tell us.
Yes.
If we can hear it, we will. Otherwise, we'll pass this order and place it before the
2020,
Chief Justice for
yeah.
hearing it along with the.
But Lord may hear
Yeah,
it,
yeah.
my lord, because they only challenged the consensual agreement.
Yes, your lordship may hear this, because there is no, my lord, challenge to the rule. Your lordship may hear this, my lord, the date may be fixed, my lord will assist your lordship.
Then all this is not required. No appearance for the petitioner, list on so and so date for hearing.
Already go then, but. See, sorry, my lord, but in effect, we thought it may,
There may,
It may touch upon the rule, but the rule has not been. made.
there will
But-
be a conflict, we'll list it along
but the
with
prayer is only simply that they've challenged this consensual agreement.
If the petitioner's counsel comes,
Yes,
probably he'll want it listed along with the PIL. So let it be listed along with the PIL is what we feel. There should not be any conflict of orders
Please,
between two benches of the court.
quite see.
Should not happen. First order, listed along with the PIL. Please give the number. of
I'll
the-
do the needful.
Please. First order. 40 urgent, 41.
Respondent in this matter, lots, this is the matter, lots where the husband has challenged the appeal. Lots, marriage is dissolved.
Hmm.
Thereafter, lots, the respondent wife has remarried. Lots,
Nothing.
and they have
survives.
they have also not paid any maintenance lots which was ordered by the trial court.
Yes. Practically nothing survives.
Yes.
Yes.
Lots may kindly call it next week, lots.
Sure.
2:30 lots.
We'll make an attempt. We'll have to communicate again with you, because there may be some.
2:30,
We'll
much
make
of-
an attempt.
Please. Much.
42, government advocate.
Yes.
In this matter, I'm praying for a week's time, my lord. My file is misplaced, my lord. I'll look for the file or build up another file. My lord, this is a matter wherein the respondent was initially granted certain extent of land. He was under unauthorized occupation of certain extent of Gomal land. It was regularized in his favor by the regularization committee. My
Yes.
lord, earlier point of time when Sagovali chit was not issued, he had come up in a writ petition. And then Sagovali chit was issued in his favor. Thereafter, certain villagers initiated proceedings under section 108D, subclause 6 of the KLR rules, stating that this particular regularization of land ought not to have been done in favor of the petitioner. I'm sorry, the respondent. My lord, that the assistant commissioner allowed that appeal. That was challenged by the respondent hearing before the honorable KAT, my lord. The KAT allowed the appeal of the respondent and it was granted in his favor. Subsequent to that, my lord, Tahsildar has initiated inquiry again, wherein all the grants which were made at that period, including the respondent's grant, all the grants were challenged under section 108D, subclause 6 of the KLR rules, wherein the president of the regularization committee only was made a party. The grantees were not made parties. That order was allowed, my lord. That was challenged by the respondent herein in the writ petition, my lord. The learned single judge allowed the writ petition on the ground that there cannot be a re-inquiry so far as this petitioner, the respondent is concerned. And since no notice, he was not a party in those proceedings. Re-inquiry could not have been initiated against this respondent, against which the state has come up in appeal, my lord. My lord, the appeal, I'm not aware of the grounds because I don't have the file, my lord. May kindly be called after 1 week or 2 weeks, my lord. A date may be fixed. I shall get ready and we shall submit, my lord.
Government advocate submits.
My learned friend said is correct, sir, except one or two. Sagovali chit was not issued. We came up before this honorable court and direction was given. Again, contempt was filed. In contempt, Sagovali chit was issued. Revenue entry was not made in our favor. We filed a writ petition. Thereafter, based on the mandamus, again they have not done. Again, contempt was filed. In the contempt, revenue entry
At
was
those
made in our
stages,
favor.
at those stages, these contentions were not raised.
However, my lord, it may not have, but 4 or 5 times the government have made us to run from pillar to post. Before the assistant commissioner also, what my learned friend said, KAT have allowed the appeal. In spite of it, my lord, without making any of the parties, they have assistant committee, making only the, as she told, He was only made as party and an order was passed behind our back, which was called in question. My lord, there is no infirmity in the order passed by the learned single judge.
What does the learned single judge say that it is bad for,
We
Because
were
there
not
was
making the party.
that is all.
re-inquiry.
He has considered all other previous round of litigations also has considered all other things.
Only
all
on the
other
ground
aspects
that
of it.
re-inquiry could not have been initiated against this
He has considered
petitioner
all
or
those
the respondent
things.
herein, the writ petition was allowed.
Yes, we'll have this learned government advocate seeks a short adjournment in the
Last
matter.
week of October, my lord.
List for hearing 24th. On 29th,
Yes,
29th of October.
Obliged.
much.
Forty-three. Kavita D.
3 I appear for the appellant. This is a matter pertaining to payment of gratuity.
Yes.
I'm challenging the order of the single judge minutes. The appellant herein was working with
Appears
the,
against you, HMT machine tools. There is appearance, I mean.
the
Name was shown.
location, but there's
Nine,
appearance.
8 or 9.
Imana Bhatt. Government advocate.
Timmanna Bhatt CGC. Government advocate for R3, R4. R6, R8, R5. Yes.
Only R1 is a responding. Others are not relevant because they are also sailing with us. Answering respondent is only respond number 1. I'll just make my submission, then the time may be given for respond number 1 to make the submissions.
Yes.
The appellant was an employee of the respond number 1, my lords. He joined in 1982 and superannuated in the year 2012, 13/9/2012. The gratuity was not paid to the appellant. Hence, he filed an application under 7 for payment of gratuity. On 16/5/2014, order was passed for payment of gratuity.
Yes.
Later, the order only was partially complied. On 16/12/2014, they paid only the principal amount. The interest was not paid. Hence, I filed one more application under section 8 for payment of compounded interest.
Yes.
That was allowed, my lords. That is in page number 54. The controlling authority ordered that you have to pay the compounded interest under section 8. 15% compounded interest has to be paid. That order was challenged by them before the single judge.
Only the second order was challenged with
Only
regard
the
to
second
payment
order.
of interest.
Please,
was
Manoj.
challenge.
In fact, the payment of first order was also challenged because they have the appeal remedy. They didn't take the appeal remedy. While challenging this, subsequently, they also challenged the order passed by the controlling authority at the first instance. Now, the order of the single judge, my lords, is at page number 17. Relevant portion are at page number 22, my lords. The single judge orders that only 10% of interest has to be given.
Because the company is
Manoj, the
Sikh industry.
the contention of the respondent number 1 is that the company is Sikh industry.
BIS.
They are not the Sikh industries. Earlier in 2002, they had become a Sikh industry, my lords. Then after the Sikh industry was abated and the NCLT came into, IBC came into proceedings. At that time, they didn't take the benefit of the scheme. And they came out of the Sikh industry in the 2008 itself. My claim is of the year 2014. And the respondent number 1 has not even produced a single document to show that they are the Sikh industry.
Petitioners hereby directed to pay the gratuity amount due to the respondent number 5 and 6 as determined by number 1 and interest at 10% per annum on the amounts due from the
Only
date of the amount.
on this portion of the order, I am agreed, my lords. Hence, I filed an appeal. And
The
a similar,
statutory interest.
please, Manoj, it's a statutory interest under section 8.
Yes,
May I read section 8, my lords?
please.
If the amount of gratuity payable under this act is not paid by the employer within the prescribed time to the person entitled thereto, the controlling authority shall, on an application made to it in this behalf by the aggrieved person, issue a certificate for the amount to the collector, who shall recover the same together with compound interest at the rate such as the central government may by notification specify. Central government has notified 15% interest, my lords, from the date of expiry of the prescribed time as arrears of land revenue and pay the same to the person entitled thereto. Provided that the controlling authority shall, before issuing a certificate under this section, give an employer a reasonable opportunity of showing cause against the issue of such certificate. Provided further that the amount of interest payable under this section shall in no case exceed the amount of gratuity payable under this act. And similar matter was considered by the Supreme Court. Manas, I have produced the one citation, judgment of the Supreme Court, Manas. Ganga Hanumegowda versus Karnataka Agro Industries Corporation Limited. It's 2003, 3 SCC 40 Manas. In that paragraph number 2 Manas. I'll read out Manas.
Yes.
A limited point that arises for consideration and decision in this appeal is whether the division bench of the High Court, having found the appellant entitled to interest on belated payment of gratuity, was right in denying the same, holding that the discretion exercised by the learned single judge in that regard was not arbitrary. This is answered in paragraph number 7, my lords. My lords, may come to placetum G, my lords. I'll only read last 4 lines of that's the answer given by the Supreme Court. The collector shall recover the amount of the gratuity with compound interest thereto as arrears of land revenue and pay the same to the person entitled. A penal provision is also made in section 9 for the non-payment of gratuity. Payment of gratuity with or without interest, as the case may be, doesn't lie in the domain of the discretion, but it is a statutory compulsion. Specific benefits expressed given in the social beneficial legislation cannot be ordinarily denied. This is the finding given by the Supreme Court, Manas, and they set aside the order of the single judge and division bench. The only point to be considered in this case is also same, Manas, whether the single judge has a discretion to reduce the amount of interest when it is a statutory compulsion.
If the company was in BIFR at the relevant time, what would be the?
Then they have the discretion. Single judge has a discretionary power, Manas, to reduce because the statute provides for that. And in the whole writ petition, they have not even produced a single document to show that they are Sikh industries. Orally, they are making submission in all other court. This is not a single matter, Manas. There are several matters against the company. All are before the single judge. But this is the only matter which has attained finality before the single judge and come here. In all those matters, they are taking contention that they are the Sikh industries. But not even a single document has been produced by them to show that they are the Sikh industries. If they produce some document or if they substantiate that they are the Sikh industries, then yes, the discretion can be availed by the respondent number 1. Otherwise, it's a statutory compulsion. 15% component interest has to be given to the appellant.
Panel councillors.
Yes, this appears to be, if there is a statutory interest provided, like in EPF and gratuity.
Indeed.
Don't have the power to reduce it unless, of course, there is some compelling circumstance.
Correct.
Normal discretion is not available in such matters. Wait for the panel counsel.
Please.
Pass over today.
Not the panel counsel. I have his number. I'll just call him and inform so that the matter may be disposed. It's a small matter, Manas.
Pass over.
Pass on, Manas.
Okay. 44. Murali Krishna, Brahmanandam, Venkatesh P. Dalwai.
The council that amicus curiae appointed by this honorable court has sought for an adjournment.
What is the matter about?
This is, petition has been filed, praying for setting aside of the decree of divorce granted.
Your lordship, my senior is out of station. If you could just grant a day or two time.
List it on someday next week. Yes,
Lordship, I can-
learned amicus curiae seeks time, list
511.
511. Is that all right? Yes.
Adjourn.
Everything else is the trial court records are available? Are they required?
It's here.
Yes, it is admitted.
Yes.
45. B.R. Vishwanath.
We'll make an attempt to pass it over and see.
46 urgent, 47 urgent.
48. KEA.
48. Himaya.
Yeah, for the respondent.
H.
Yes,
48 last.
you're also
According to me, this has become infructuous.
probably has become infructuous.
But I do not know, because he wants an upgradation of the seat, which has, in the mop-up round normally, my lord, it's a fortuitous round.
Correct.
Wherever, my lord, the remaining seats, those seats sometimes, my lord, go to lower rank students.
Correct. Correct.
Here, my lord, she takes a seat, she goes and joins the college. This thing would be, my lord, the allotment of seat logic would be, my lord, on the basis of their options entered
Correct.
and on the basis of the ranking they obtained. She goes to a college, but she joins that college also. It's a management quota she got. She goes and joins the college.
Mm.
After that, my lord, she found, my lord, that some
Some
seats
mop-up
were,
round in some other.
yeah, some of the lower ranking. But our instructions are, my lord, very clear.
Mm.
In the mop-up round, my lord, seats children who have already taken, my lord, the seat and joined the college, they're not.
That is done, it is done, and the mop-up is a separate
Separate, yes,
exercise
yes,
altogether.
that is the case. And my lord, the brochure, my lord, the specification, the brochure is held to be
Provided
the rule, my
specific.
lord, in the division bench of this honorable court has already held. I have the judgment with me.
Oh, sorry, my
Yes,
lord, I'm
yes.
petition. My lords, I've filed a memo for withdrawal itself, my lords. That was filed last year. My lords,
Yes.
frankly, my lords, one issue does survive, but the petitioner is not interested in pursuing it.
The difficulty is that that issue that survives, we've seen in the brochures, what do you call it? It is specifically mentioned in the brochures
Yes.
that once you take the admission, then you are out of the reckoning for further rounds of.
Yes, my lord, which is why we had challenged that also. There is one prayer in that regard, which is my prayer B.
Hmm.
Where I've said quashing the general instructions, number 1, provided under the medical mop-up round eligibility criteria. So and so released
As
by.
a matter of fact, how else can you cannot have a completely foolproof method of allotments.
That's
There has to be some kind of, if you say that the remaining seats will be available even to persons who have taken, then it does not become a mop-up round at all. It becomes another round of
Then
of counseling.
But what
Contemplate.
happens, they must take action against students who drop out. One is that if I have to take my seat,
Also-
I have to give my original documents and I have to pay the fee.
Correct.
If somebody pays that amount and deposits their original documents, they will not drop out. The fact that they're permitting it, there must be a loophole is what we are saying.
There are situations where, imagine a situation, there was a case today itself. There is a case where the father lost his job. He's unable to make the remaining payment. He wants to withdraw. He says he has given the application even before the last day. There are situations where you cannot say that a person should be penalized in all circumstances.
No, but they must at least have an inquiry to find out what the situation was, because there are 10 seats that have opened up subsequently.
Hmm.
Not 1 or 2, there are 10 seats.
Hmm.
Now, I should have ideally got one of those 10 seats. And that would have also, it gives
You're
me a,
right, you're
gives me a
right.
saving of 75 lakhs, my lords, for the 5 years.
May be correct, but then the situation is such that in how many seats are we talking about on an aggregate?
In this college itself, 10 seats, my lords, for the,
How many seats are we talking about for the counseling on an aggregate? In such
Very less,
situations,
very less.
in
But
such
8,000 seats.
situations to say that.
Total 8,000 seats, everybody will start
Absolutely,
asking
that
that.
is what we are saying.
Yes, yes, yes.
If the number of seats are taken into account, to say that some seats may not be left over after the entire counseling process is over, may not be practical. There can be situations where actually dropping out is warranted because of the sheer size of the numbers.
We have to start all over.
That
From,
cannot be.
Also,
Anyway,
in-
you're sincere.
that is an academic point, my lords, because of the fact that the
Correct.
petitioner is not
And-
interested
and-
in pursuing it.
Because of the point that we have time today, which may not be available on normal days. Yes,
I filed the memo last year itself, 29th August 23.
Employment Council
It's not been put up though.
petitioner submits that a memo has been filed seeking withdrawal of the writ petition. Yes, the memo is recorded.
As the main relief has become infructuous.
The writ petition is dismissed as having become infructuous.
Clear.
It's dismissed as withdrawn.
All right. Lords, my name may kindly be shown, my lords, by deleting the name of the.
Yes, dismissed as withdrawn.
Madena.
first day.
Yes, this is a luxury we have only on days like this. We'll come back at 2:30, see whether
Yeah, that.
if any of the passed over matters there are.
There's one passover matter, education matter.
Yes, we'll come back at 2:30. Let's see. if the-
35 minutes.
Yes. Yes,
I am not sure as to whether it has been passed over or adjourned.
just a moment. Adjourned to 28. It was passed over once, but it has now been adjourned to 28th.
Much obliged. Much obliged.
giving date to them.
First job matters, list one, number 32, Siddharth Agnatis.
Step. Please.
Sign it.
No difficult. Eight others who are more meritorious is what they say, paragraph 4. Yes.
Lord, my respectful submission is in the memo that I have filed today, the last page, it recognizes, my lords, that I am a candidate. In the category, it says 2AGR. That's where it should be sports as per the interim order at page 9, my lords, of the memo. This is, my lords, the form. It says Saurabh Holepagol, who's the petitioner. Then it says candidate category 2AGR. Here it must say SPO or sports. So that I am able to take a sports quota seat. Therefore, this is, my lords, they have not really implemented the.
In any view of the matter, the sports quota seat is now kept vacant for you. You've
Please.
been permitted to take the mop-up counseling also.
Please, my lords.
Now, if as a matter of fact, you are found to be eligible,
Please,
then there is a seat vacant awaiting you.
please. my lords.
So therefore, basically, you would not be put to a prejudice because of the fact that
I
what
bow
is
down.
shown here is 2AGR.
I bow down, my lords, to what falls from your lordships, subject to only one point that if SPO were shown here, I would have had the choice of one of the 3 institutions. Today, I won't know which seat is reserved in which institution. That's the only prejudice, limited prejudice that I will suffer. If they don't implement the interim order as it is specifically ordered, which they still can because this is open till midnight tonight.
But the first parallel should not be heard of the eligibility.
No, that is correct. But then we are at the stage where there is already an interim order. We are not considering an application for varying the interim order.
Kasturba Medical College.
Madhusudan Sai.
What are we looking at?
Science and Chikbalapur. See this? See, totally there were 7 These are the seats. But these seats are from first round. But nothing prevented the petitioner from challenging this during the first round.
Correct.
He waited. But he is virtually a fence sitter.
So
He is a fence sitter.
when was the, what do you call the,
Counseling.
when was the notification issued in the first place, showing this specific,
Ineligibility of the petitioner.
no, the notification with regard to admission?
Notification regards to admission in March itself.
January.
Then itself, this provision with regard to the sports quota
Quota was
was
there.
there.
Yes.
And this amended provision with regard to
Provisions were in force
from March itself.
from on that date.
On 16/3/2024.
They were in
As
force.
per Annex A.
Because we do as per the government's notification only, government's rules, whatever the rules applicable to sports, NCC, whatever category, we abide by that. So that was already there in force. As per that too, I will take your last to that. It's a special category, sports. But we don't have wherewithal to see who is
Correct,
eligible.
correct. It is
So-
not for you to do.
Yes, what we do, all the students who are claimed under eligibility, with their certificates, we send it to the Department of Youth and Services, Director Department of Youth Service, who is the authority. That authority is not made a party here. They give a list, they give an eligibility list, they give an ineligible list also. Both the lists they have given. As per the rules, as on that day, petitioner was ineligible. So therefore, his the question of he coming in the first round or the second round doesn't arise.
No, even if his writ petition is allowed
Yes,
and the provision is quashed,
yes.
then he would not be the person who would benefit, because there would be others who.
Other students are already, they are not before the court at all.
I'll answer that, my lords. First, in terms of facts, my lord, on 10th of January, the initial notification was made for this year CET. On 10th of February, I applied. On 16th of March, the amendment notification came to be issued. So the amendment notification is after I made my application.
It may be, but it is on 16/3.
On 16/3.
16/3/24.
Therefore, my lord,
The writ petition
candidly-
was filed after the first round of
Please, my lords.
There again, the difficulty is this.
Please,
If as a matter of fact, it is found to be incorrect
please,
or confusing or whatever, for
Please.
whatever reason,
please,
it has to be corrected in any manner.
please, my lords.
It cannot be corrected for one person.
Right.
It is an admission notification,
Please, my lords.
and your contention cannot be that because they made an incorrect provision in the notification,
Please, my lords.
you should be appointed. That cannot be. If there is any error in the notification, that goes, and therefore anybody who's eligible will have to be considered.
Lord,
There, my lords, my two submissions are as follows. Lords, firstly, none of the other students are before your lordships. None of the others in the category. Therefore, my lords, there is a good possibility they have already taken other seats. And if that is so, then this point, so far as their rights are concerned, becomes academic. That, my lords, is my first submission. Therefore, it's a question of fact, which, my lords, they have the data with them. They must present saying, these are the 8 students. My information, my lords, from public records tells me many of them have applied, but my lords, these names can be confusing. Therefore, they are the custodian of that data.
But there again is the difficulty. If as a matter of fact, on 16/3/2024, when it was notified, there was
Please,
a
please.
challenge.
Please,
And all this would have been.
Indeed, my lords, I have come late.
But we've come at a
I have come
stage of
late.
mop up.
Please, my lords. Now, my respectful submission, my lords, is that at least in the mop-up, my lords, I understand I have come late. Therefore, there must be some consequence. Round 1 and round 2, my lords, your lordships may say, we will not upset it because it is now a matter of the past that I have come too late. But my lord, so far as mop-up round is concerned, at least my right can then be recognized. Otherwise, this will now become a general category or a management category seat. That is, somebody who is willing to pay more money than me will get the seat. Instead of that, my lords, that benefit may be given to me. Secondly, my lords, my respectful submission is for those other 8 persons. If they are not before this honorable court at this interim stage, then, my lords, this interim order they should enforce,
No,
so far as I am concerned.
Interim order enforcement, we understand, we are with you. But then for an interim order is to aid a final order. What is the final order that can be passed if in a situation like this, we are not in anything else, you are right. The person who comes here, we are in the situation of an admission procedure for a medical seat.
Please, my lords.
The procedure must apply to everybody.
Please, my lords. In that event, my lords, my respectful submission is for the mop-up round, they may have to redraw their eligibility list and all those according to them, my lords. Now there are 8 people above me according to them. I'll have the opportunity, my lords. If there are 2 seats, let the top 2 meritorious out of the 8 get it. If my lords, they believe that is what needs to be done. Because my respectful submission is.
Then the question would be, is that exercise warranted in the facts of this case? Is that exercise warranted would be the next question we have.
Please, my lords. There, my lords, my respectful submission is one is not dealing with lakhs of students, it is 9. 2, my lords, there is a provision which, if interpreted the way I am requesting this honorable court to do, will provide a benefit as against the interpretation of the state, which will not provide the benefit. Third, my lords, therefore, if one were to, my lords, consider beneficial interpretation, it will come to my rescue or my aid. Thirdly, my lords, this is to a certain extent changing the rules of the game in the middle. When I played the sport, the rule, and very fairly, my lords, they have said in their objection statement that when I played the sport, the rule was not capable of any ambiguity at all. The rule was, so long as I have played one sport, I will be entitled to participate in the sports category, subject to inter se merit. Even on the date I applied, that was the rule. Subsequently, they issued a notification. And because they subsequently issued a notification, they extended the timeline for filing of the applications a little more. Therefore, my lords, to a certain extent, fairness also, my lords, that it is like when I'm writing 10th standard exam, they say, if you get more than 80, you will be entitled to medical seat. But after I finish 12th, they say, no, it must be 85 now. And my lords, in terms of inconvenience that it may cause them in terms of final relief, this is about 9 students and about 3 seats. So it is not a mind-boggling number. It does not require tremendous amounts of administrative exercise. 9 students
That-
and 3 seats.
There are difficulties from the directions issued by the Supreme Court. We cannot, 1 and 2 rounds which have already been
Please, my lords.
conducted, we cannot touch.
I'm not even asking, my lords. Only so far as mop-up round is concerned, because without doubt, I have come before the mop-up round. I have come after the first round, after the second round, but I have come at before the mop-up round, which is why the interim order was passed only in respect of the mop-up round. Therefore, students who are allotted seats in round 1 and round 2, my lords, although my prayer says so, my lords, your lordship may not grant that relief.
We cannot grant.
Please, my lords. Therefore, so far as only mop-up round is concerned, to my knowledge, there are 3 seats left in the mop-up round. And even assuming their version is correct, including me, there are 9 candidates vying for those 3 seats.
If your seat, the seat which has now been reserved to you is also considered, there are 4 seats. And there again, there are identically situated persons as you are 8. There could be others in the sports quota.
And who are higher rank.
No,
This is-
the others are eligible students as per the notification.
They would also be there.
Yes.
Then relative merit would have to be taken into account.
Yes.
Then they would also have to be, now at this stage, saying all this, asking them to come for the mop-up, people who have not been, whose names have been
Yes.
apparently rejected, requiring them to come for the mop-up and participate today, not going to happen.
No, my respectful submission is, lords, so far as the first list is concerned, there was a list of eligible candidates and ineligible candidates. If, my lords, my interpretation succeeds, there are 4 people who are in the eligible list who have taken seats, who have scored less marks than me. Therefore, everybody else today in the eligible list on inter se merit will come below me. There are only 8 persons sitting above me, whether they were in the original eligible list or ineligible list. Therefore, my lords, if any of those 8 take this seat, then I may be deprived. If none of those 8 come forward, I will be one of the beneficiaries. Lords, now my respectful submission is this may cause some amount of administrative work, but my lord, will that be a reason to deprive me? It may amount to some work. That, my lords, I admit.
Well, my respectful submission at this point is that amounts, my lord, virtually, my lord, your lordships are holding that the rules is bad in law.
It does not. It does not, because as a matter of fact, the interim order only says
Yes.
he will be permitted to participate in the mop-up round.
Mop-up round of counseling.
In the sports quota.
Yes.
And that everything else, and one seat will be kept vacant for him. That you've already done.
Yes.
Now, the only issue is if he's permitted to participate in the sports quota, then also the question whether he's, as a matter of fact, eligible, and whether there is anything wrong in the prescription in the
Yeah,
syllabus.
only
That will
one-
have to be considered, I mean, in the,
Well, this seat, my lord, if your lordship, well, since it has been earmarked only for him, nobody else. They have already taken the seat. Unless they are made parties, my lord, then
they've taken one, the others have taken.
they've taken.
Which ones?
The colleges have been taken.
No, no.
Seven.
What happens, lord? One seat,
7 seats are now taken, according to you.
yes.
The 7th one was
Seventh-
taken pursuant to.
Only one seat which is now reserved that has been kept
Yes,
vacant.
the result for mop-up as per court order. This is reserved for mop-up. What happens, lord, in the mop-up, everything gets, my lord, converted. Even this
Correct.
could have been converted to the general category. He wouldn't have got it.
Correct.
So, my lord, we kept this apart.
So therefore, the fact that he has been permitted to participate itself and that this has been reserved for him
These are
is,
for him, we will give it to him.
Not. If he is eligible.
If he is eligible, otherwise, my lord, subject to the result of the petition.
correct, of course. So now if this is the situation
Please, my lords.
and that there is only one seat left in the sports quota,
Yes.
My lords.
then you're not put to any other prejudice because that seat is reserved for you.
Lord, this document that my learned senior friend has given, if your lordship will see, my lords, it says converted to GM.
Hmm.
Yeah, one seat was
No, my lords.
converted already.
This conversion could not have happened in the face of the interim order. Because, my lords,
No, the conversion has not happened in this
it
mop-up.
always happens after second round.
It has already happened in the second round.
Lords, my Lordship,
No, no, it happens in the
it
second round
happens
itself.
This-
not at the second round, after the second.
Second,
No, no,
we understand.
Please,
Your interim order
please,
does not say that there should be no conversion.
please.
Interim order only says one seat should be kept vacant. You must be permitted to participate
Please,
in
Manoj.
the mop-up. In the sports quota, in the mop-up, there is no quota. In the mop-up, as a matter of fact, there is no quota.
Please, Manoj.
Now, one post is there, it is kept
Please.
vacant for you.
Please,
Let us stop things at that and let us argue it on the merits of the matter.
Please.
And if, as a matter of fact, you are entitled, you get the seat.
please.
If you're not, you don't. We'll
Please, Manoj.
leave things at that. Because like you said, the others have not come. Maybe
Please.
all those are matters which we'll have to factor in. We cannot invite people to come and
Please.
litigate. So now as a matter of fact, you are the sole sports quota person now challenging the
Please,
rule,
Manoj.
and therefore you will have to, on your own merits, you will have to stand off all.
Please, Manoj.
Consider it on the merits. Now, as things stand, let things be.
Then my only request is let it be recorded, Manoj, that this seat in Chikballapur is reserved for me should I succeed in the
Yes,
writ
yes,
petition.
That
we'll
is-
record all this.
We have
Please.
said that. This
The
is there.
entire arguments that have gone on, we'll record in short.
Please, grateful.
We've heard the learned counsel. Learned senior counsel appearing for the petitioner, as well as the learned counsel
Right.
appearing for the KEA and the learned government advocate. Sorry, see the counsel appearing for the petitioner, as well as learned counsel appearing for the respondent KEA, as well as the learned government advocate. It is submitted by the learned counsel appearing for the petitioner that this court, by interim order dated 19/9/2024, had directed a seat in the sports quota in the MBBS course, if available, shall not be allotted to any student. And further, that the petitioner shall be permitted to participate on merits in the mop-up round in the sports category. The learned counsel appearing for the KEA submits that in deference to the order, a seat in the Sri Madhusudan Sai Institute of Medical Sciences and Research, Chikballapur, has been kept apart and reserved to accommodate the petitioner in case he is successful in the writ petition. It is submitted that since the remaining allotment is only in the mop-up round, there is no specific category prescribed for the mop-up round of counseling. And as such, the and that as such, the petitioner has been permitted to participate in the mop-up round of counseling. Full stop. It is submitted that since there was only one seat left in the sports quota, which has been kept apart to accommodate the petitioner in case he succeeds in the writ petition, there is no violation of the interim order. Having considered the contentions advanced on either side, and in view of the fact that one seat has been reserved to accommodate the one seat in the sports quota in the Sri Madhusudan Sai Institute of Medical Sciences and Research, Chikballapur, has been reserved to accommodate the petitioner in case he succeeds in the writ petition. We are of the opinion that the interim order stands substantially complied with. List on,
Government has to file a short counter for this because this is their rule.
because the rule is under challenge.
Yes.
We'll do that.
Yes. Do you want to implead, who do you
Manoj,
say has to
yeah,
be
I said
impleed?
what the director of.
Director Department Youth Empowerment and
Well,
Sports?
that,
Please do that. Yes, the petitioner shall implead the Director Department of Youth
Youth Empowerment and
Youth
Sports.
Empowerment and Sports as a party to this writ petition.
the state will take notice.
The state Is it available? For whom the learned government advocate shall take notice. List after, please make available the application also. So if it is filed today itself, we can order it. Otherwise, it will again take time. Can you make available the copies?
One second.
No, we'll await that. Please make it available so that the order can be passed on this.
Yes.
On this itself. Otherwise, it will may delay the, and there is somebody else. If as a matter of fact, you are not found eligible, that it should go to somebody else. That is also another issue that we can't keep it pending too long.
Yeah, next week we'll also have it. Madam. Anyway, my statement is over. This is all the statement which I can say.
Next week means. Can we have this 23rd?
Please, madam.
Can you make the pleadings complete by then?
Madam.
Yes.
Please.
So on, so director, IA number. The Directorate of Youth Empowerment and Sports is impleaded as a party respondent, is impleaded as a respondent number 3 to the petition. Learned government advocate takes notice for the additionally impleaded third respondent and seeks time to place a counter of it on record. List on 23rd. The petitioner shall produce the amended copy of the writ petition by then. Yes, please accept the objections as well. Yes.
Grateful.
Taken on record. To amend the cost date.
$41, Dhanraj Pictures.
Fact notes, 2 petitions were filed. One by the husband and one by the respondent notes. Husband filed the petition for conjugal rights and I filed the petition for divorce on the ground of cruelty. Notes, the petition filed by the husband,
When was the marriage? 2016.
please notes.
From when have you been staying separately?
Notes, as on the date of my petition, I was staying separately for more than 1.5 years.
Since
And-
5/6/2019.
Please notes. And the petition filed by him came to be dismissed and my petition came to be allowed, granting me decree of divorce notes. Thereafter notes on 2023 notes, the respondent has remarried notes. Just give the date notes.
18/10/21 was the
Decree notes.
decree.
Yes, notes.
And when was the appeal filed?
Appeal was filed
28/3/22.
22 notes.
By the time had elapsed
Lapsed.
and you had remarried.
And notes, he did not comply with the notes findings of the trial court also. There is a direction notes by the trial court to pay alimony of rupees 10 lakh and he has not paid that. And notes, he has admitted that he has taken 100 grams of gold and that has also not been returned.
100 what?
100 grams of gold notes. And he has not complied with it. And notes, I have remarried on 26/1/2023. And nothing survives. And one more submission is The appeal filed by him is only with respect to the petition filed by him seeking Lord's conjugal rights. It's not against the Lord's decree of divorce. So therefore, nothing survives in this appeal, Lords.
We cannot dismiss it on merits. Without hearing the appellant, without hearing the appellant, it cannot be dismissed on merits.
No, Lords, I am not on that. I am only placing the
can-
facts before this honorable court.
One thing we can do is
Please, Lords,
we can dismiss it for default.
much of it.
And if, as a matter of fact, he has.
If he comes, then it can be taken up on merits. Because Lords,
This appeal. When this appeal was called in the morning, there was no appearance for the appellant. The matter was passed over and taken up again in the afternoon session. There is still no appearance for the appellant in the above view of the matter. Hmm? You can just dismiss this for default. And then if he really wants, if he has any sustainable, let him come in. Then we'll hear it on merits. Yes, appeal is dismissed for default,
much of it.
for non-prosecution. Absolutely, absolutely. Even if it is argued on merits, we probably will not be able to allow it because you're already married.
Please,
We
Lords.
cannot
And
allow
that is not
restitution.
challenged. Lords, my humble submission is that
That-
decree is not challenged.
Probably, let us,
Please.
anyway, let it be dismissed for default. If he does not come, that is the end of the matter. If he does come, we'll.
And he knows this fact also.
Yes. Payment of gratuity. Yes, HMT,
Sorry, my lord, I was.
HMT machine tools.
Lord, it's a sick company, my lord.
What is that? The contention urged in the morning was that there is nothing to show that it is a sick company.
No, the sick
Not-
company declared as a sick company, my lord. There are,
There-
my lord, it's admittedly, my lord, I don't.
Now that admitted issue is a problem. Nobody's admitting.
It's a sick company, my lord. There's a order passed by the BIFR.
Where is that?
I have not produced that, my lord, along with this, my lord.
Unless you produce that, how can you rely on it?
My lord. In fact, my lord, in this case,
Hmm.
we also paid the 10% interest. We have paid the gratuity amount by delay. There is
The
about two.
difficulty is this, it is not some kind of a concession that interest is paid. Interest is statutory.
Yes, my lord, we have paid that.
Gratuity Act provides for an interest. Gratuity and PF. The interest is statutory payment and it cannot, even this court cannot detract from such statutory payments unless there is something specific to show that you are unable to pay.
Yes, ma'am. Yes, ma'am. No, in fact, in this matter, ma'am, I engaged the services of senior counsel. He's arguing in connected matters before the single judge. That matter was parted and now posted after vacation. That's why, ma'am,
Difficulty is that this court, in exercise of its jurisdiction, even the learned single judge exercising jurisdiction under 226, cannot reduce the rates of interest which are statutorily set.
yes, ma'am. But as per the learned single judge order, we have paid the interest at 10%.
That 10%
During
cannot do.
During the pendency of the writ petition, writ appeal, they have paid 10% interest also.
How can the learned single judge reduce the rate of interest is the question.
Compound, now they are claiming compound interest.
It's what the act says that they are entitled to.
My lord,
Compound interest is what the act says you must pay. If you don't pay in time, then compound interest is provided under the act.
if it is not recovered,
Hmm.
then they can recover with compound interest.
Hmm.
Since you already paid the gratuity amount,
When,
immediately after 2 years of the retirement, you have paid the gratuity amount.
therefore, for the period,
For that
till-
period,
till the date you paid the gratuity
my
amount,
lord,
you
my
have
lord.
to pay the compound interest.
Section 8, my lord. Section 8, my read, my lord. The amount of gratuity payable under this act is not paid by the employee within a prescribed time. The person entitled thereto, the controlling authority shall, on an application made to it in this regard, behalf by the aggrieved person, issue certificate for that amount to the collector, who shall recover the same together with compound interest thereon. And that rate is prescribed by the central government.
At such rate.
Provided that, yes, ma'am, that will be, notification will be issued by central government. Provided that the controlling authority shall, before issuing a certificate under this section, give the employer a reasonable opportunity of showing cause against the issue of such certificate. That is the.
All that has been done.
Yeah, my lord, that's what, my lord. In this case, we have paid the gratuity amount. There was a 2 years delay, but for 2 years also we have paid interest. There was a delay. There is a.
Not at 10%, at the statutory rate.
Rate is 10%.
Statutory rate is not 10%.
10%.
15% compound.
No, the compound interest is 15%. But statutory under section 7(3)(a), court has fixed 10%. And even this order, my lord, may read the order, my lord. Order of the controlling authority. Page 91, my lord. Starts from 91, annexure N. My lord, page number 94. The application is allowed. The respondent is directed to pay gratuity amount of 3,99,237 to CH Ravindra. The application applicant along with the simple interest rate of 10% per annum with effect from 1/10/2012 till the date of final payment within 30 days from the date of receipt of the order.
When was that final payment made?
Final payment.
You should have made that payment within 30 days.
Yes, my lord.
Did not.
That's
You
why, my lord.
paid it after two
That's why, my lord,
years.
10% interest will applicable.
That 10% you are right.
Yes.
Till the date when the controlling authority directed the payment.
Correct.
Perfectly correct.
Yes, ma'am.
If you had paid within 30 days, you need pay only 10%.
Yes, ma'am.
But the day after the 30th day, from 31st day onwards, till the date of payment, it has to be at the rates as fixed by the, as statutory.
No,
rates.
then there is a procedure. They have to initiate recovery. They have to recover it. Then the compound interest is payable.
Even otherwise it is
Because-
payable.
Please, my lord.
Even otherwise it is payable.
In this case, that's some, lord, I just pray for some accommodation, because since senior counsel is arguing in other matter.
That we can, but
Yes,
the
my lord.
difficulty
Yeah,
is,
we will examine that, my lord.
the
We also-
difficulty is this,
Yes,
whether
my lord. Yes,
this
my lord.
court, the learned single judge, would have directed the payment of anything less. When the rate of interest is statutory, in the facts, on facts you can argue, no difficulty. But if as a matter of fact, you did not pay within the time as provided, then when it is paid, it
From
must carry the
Yes,
interest.
ma'am. From the date of
date,
the
the date.
liability till the
Correct.
date of payment,
Yes,
we are liable to pay 10%. That has been paid, my lord. That is the,
from the date of entitlement till the date when it is paid, it is 10%. If as a matter of fact, there is a direction to pay, which has not been complied with,
yes, ma'am.
then it becomes a compound rate. This appears to be the situation. Unless on facts you can differentiate.
Examine, my lord, since it's a sick company, my lord, that's why, my lord, there is
That it is a,
I will produce that
that
copy
it
of-
is a sick company also, there is no material.
In fact, before this honorable court, we have not produced that material.
Not before this court, before the authority also, no material, before the learned single judge.
Authority has held that, my lord, authority observed that there is this is a sick company and all.
Where?
No, it is, my lord, only.
Page number 22, paragraph number 4. The retention, what we accepted, the retention that.
Yes, my lord. Yes, my lord. On And
As
other-
far as the first issue framed in 6(1) is above, the respondent did not dispute claim, wages drawn, total number of years, etc. All that is admitted. So also not less than 5 years. Employer should have obliged to comply with the requirements of 4(1). The applicant joined services on 27/9/82, superannuated on 30/9/12, thus completed 30 years. So and so, hence I am satisfied that applicant was justified. And so far as second issue is concerned. Yes. Honorable Supreme Court, where held that payment of gratuity with or without interest, as the case may be, does not lie in the domain of discretion, but is a statutory compulsion. Evident from 7(2) that as soon as gratuity becomes payable, employer, whether any application has been made or not, is obliged to determine the amount of gratuity. From provisions of Section 7, clear command has been seen mandating the employer to pay the gratuity within specified time and to pay interest on delayed payment of gratuity. No discretion is available to exempt or relieve the employer from the payment of gratuity.
That is no discretion for payment of delayed payment, my lord, 10%, 10%. My lord, that Section 8 will apply, will come into place only after, my lord, even if the default payment of gratuity and interest, then Section 8 will come into play. In this case, gratuity amount has been
So,
paid.
You did so because you were ordered to pay the gratuity within a time with 10% interest.
Yes,
If you had paid within that time, things would have stopped there. You did not. You delayed.
This order has been passed on 16/5/2014. Please, my lord, this amount has been paid on 16/12/2014.
16?
16/12/2014.
The gratuity has been paid.
Yes, my lord.
Therefore, from the date of your-
Immediately paid. Immediately after this order, after 2-3 months, it has been paid. For the delayed payment, they also paid 10%.
Interest was paid.
Yes, ma'am.
It is only a small amount.
My lord, not this is, my lord, they would have paid, my lord, but there are so many other people in queue.
There's nothing that
Because
can be
the
done
company.
unless you can establish before the controlling authority
But,
that you are in
In
BIFR
fact, my lord, in
and
other-
that not BIFR anymore, NCLT, and that you do not have the wherewithal to pay. This will keep happening because it is
But
statutory. There's no power.
all
to-
other matters, learned single judge, my lord, in all other, so many other matters, single judge accepted 10% and closed the matters.
not
And
be-
even in division bench also confirmed the same, my lord.
That is the difficulty. It cannot be.
Well, even.
Going by the Supreme Court judgment, it cannot be. The single
Well,
judge does
Supreme
not
Court
have the
judgment, my lord.
discretion to do that.
Supreme Court also has fixed 10% interest, my lord. In the learned friend has quoted the judgment. In that also, my lord, the 10% has fixed the.
That is the 10% which is statutorily fixed under Section 7.
Yes.
That or Section 8 interest, both are not, cannot be changed or lowered by the learned single judge.
Right.
If there is further delay,
In
there
fact,
is
my lord,
further delay.
Punjab and Haryana High Court, my lord, has ordered, since there is in the same, against the same company, my lord, since there is a company, Sikh company, there's no liability of interest. They ordered, my lord.
Yes.
Division, they have
Please
produced.
first show us that you are a sick company. Then we'll consider.
I'll produce that.
That is the preliminary prerequisite.
Please, no, please.
That you are a sick company at all.
Yes, my lord, I'll produce the
Are you before the NCLT now?
NCLT, no, my lord.
BIFR at that stage may not do.
AFR, my lord, they declared it a sick company, but other schemes and all, they have not continued it. That is the problem. My lord, the repercussion is very high, my lord. Now, in fact, they are not.
What
they
is
are-
legally to be
They are
done?
not in a position to pay the salaries to the present employees. For 6 months, they are not paid the salaries. Now they are paying the salary of March, April to the people working on thing.
Be
on roll.
correct. But
And they are not, there are.
they are bound by the judgments of the apex court. Please, if you require that accommodation, you will probably have to file you'll have to go before the NCLT. Without which it may not be possible. Please advise them properly.
No, no. No, my lord, I'll produce that, my lord, I'll
That will
produce,
be the end of it.
my lord, I'll produce the balance sheet, my lord. Balance sheet, my lord, shows, my lord, 412 crores is the loss. From, for 3 years, my lord, anyway, I place it before this honorable court, my lord.
Yes,
Thank you.
you're aware of the difficulty.
Yes, my lord, yes,
If
my lord.
it is statutory, then there may not be any discretion left unless you can show that you are actually before the NCLT at the relevant time. Anyway, let us see, or BIFR or NCLT, whatever, at the relevant time. When do you want it?
After 2 weeks, my lord, I mean.
At least you got your gratuity and 10% interest. In
Yes,
many
my lord.
cases,
Some people, my lord, till,
the situation
they-
would be where no amount is paid.
my lord, they
and they'll
only
be-
paid
they'll
up
be
to,
waiting.
my lord, they only paid up to the employees who have retired from services till 2019, my lord. After 2019, they are still waiting, my lord. They have not even been paid gratuity amount. That is the situation. These people have got the 10% interest also.
Give 2 weeks time.
411.
Yes.
411.
Much appreciated.
45. E.R. Vishwanath.
Ah. They're ongoing. No, if you want, we can send you for mediation also. If it is possible. No, if it is only on the amounts that the issue is. Stage. But sometimes after a little while, because of the lapse of time, the disputes may mellow down a little. You can take a chance. Well, I don't know about the maturity, but at least they get tired after a while. We'll make an attempt. So when do you want it listed? No, but the other side also has to be ready for mediation. If you will make an attempt, see whether they are ready, then we'll list this after a week. In the meanwhile, please let us know if the other side is also ready for mediation. If that is so, we'll send it for mediation, give you some time also. No, it does not even have to be mediation. It can be conciliation. An attempt at conciliation may be. Please. After a week.
25. 25. 24th.
20. Yes, the Learned Counsel for the appellant submits that there is a chance of settlement of the dispute list on 24. We're just saying there's a chance of settlement. If not, we'll hear it on merits. We won't have this chance again. We'll probably not have this chance again for the rest of this term.